If not, why don't you place that in the record about when the testimony was given?
That would be July 11th, Judge.
Of 2024, okay.
Correct.
Okay. Do you have that queued up?
I have it ready to go. Just give me 1 second.
What testing did you do?
I did our targeted screen is what it's called, and so it's a specific testing that we do if a case meets a certain criteria. So that criteria would be sex assaults, death investigations, or if it's requested by the officer. And it looks at different prescription drugs and some miscellaneous drugs.
This list that we have that I've marked as Exhibit 35A with a whole lot of different compounds on it, would that be the compounds that you test for?
Yes.
And what were your findings after doing the testing?
My testing was negative, so of the compounds on that list, I did not find any positives.
Was there a positive for marijuana metabolites? Or do you
Not
not?
on this. I did not test for that.
Is that a separate test from someone else at the lab?
Correct. It is a separate test.
And then you did a report concerning your findings, is that correct?
Yep.
And Exhibit 35, would that be the report that you did?
I believe so, yes.
And the report essentially says that you found nothing, is that right?
Yes.
It says, your report says no additional controlled substance. What's the significance of the word additional?
Yeah, so at this time we had separate reports. So we would do the initial screening and confirmational testing on one report, and then the targeted screen, which is what I did, we would do that on a separate report. So if the other analysts found, had a positive test, then on my report, if I didn't find anything, we would write no additional controlled substances.
So when you do the testing, there's a minimum threshold, is there not?
Correct, there is.
So there could be an amount in the sample or the specimen that just did not meet the threshold, is that correct?
Yes, that is correct.
So if it be a prescription drug, the fact that you said a negative finding doesn't necessarily mean that a person was not taking the drug, does it?
No, so my negative screen just means that no drugs pass that threshold is what that means. So
someone could have been taking a prescription drug at some level and been below that threshold is what I'm getting at. Is that right?
potentially, yes.
Yes. I don't have any further questions. Mr. Hoover?
Yes, me.
Just a minute.
Okay. So, Mr. Claybaugh, just so I make sure I'm understanding correctly, what you're saying is, as far as the test, did you not retest for any substance that was found positive, or it just when you retested it didn't meet the threshold?
Would you mind rephrasing that? Like, do you mean, would you
Yeah, sure. So if I understand correctly, there was an initial test done, correct?
correct, yep.
And it showed positive for some substances. Is that correct?
Correct.
And so when you did the targeted testing,
Yep.
did you not test for those substances that had already been found?
Correct. Yes. So the substances that I tested for are all on that list. All of the ones on that list. There might be, I can't exactly remember if there's some similarities with the testing. There might be a couple drugs that are similar, but of the ones that were positive and sent on for this, I don't believe there were any that were the same. It was.
Any
Yeah.
what? I'm sorry, I couldn't hear the end. I don't believe there were any what?
I'm not sure. Do you want me to? I can just kind of rephrase. I don't remember exactly what I said.
Yeah, why don't you do that?
Yeah. So I was just saying. There might be some. I can't remember exactly if there are any of the same drugs on the confirmation test with the general. There might be a few, and of the ones that were positive on that conformational tests. I don't believe any of those are on the targeted screen at all.
Okay. So, for example, if marijuana or some derivative of marijuana was on the previous test, you wouldn't have necessarily tested it on the targeted test, correct?
Correct.
And looking through that list, the THC is not on that list, correct?
Correct, yeah.
Yeah. I don't have any further questions. Thank you.
I don't have anything further. Thank you very much, Mr. Claybaugh. We are finished for the day.
All right, thank you.
All right, thank you.
Do we have another witness for the state?
We do, however, she will not be here till 11.
Okay.
And as a matter of housekeeping, Your Honor, I'd like to move to admit exhibits 34, 35, and 35A.
Yes, I meant to cover that. There was an agreement by the parties during the deposition. Mr. Hoover, I assume no objection?
That's correct, Your Honor.
Okay, for the record, 34, 35, and 35A are all admitted. Folks, good news, two things. We're ahead of schedule and you get a nice break now. Our next witness is scheduled to be here at 11. So you folks have about a half an hour. Use that time however you'd like. You can go for a walk. You can go home if you live close enough, as long as you're back by 11 o'clock. Remember the admonition. Keep an open mind about everything. Don't draw any conclusions of any kind. Make sure you report back to the jury room.
All rise for the jury.
No. No. Okay. Did you have a controlled substance named, is it cathinone? In your possession?
هل كان في حوزتك مادة ممنوعة اسمها كاثانون اسمها بحوزتك؟
نعم.
Yes.
Had you used that drug, sir?
هل استخدمت هذا المخدر أستاذ؟
نعم.
Yes.
All right. And you knew what you were using was that drug cathinone?
نعم، وأنت كنت عارف إنه هذا المخدر اللي أنت كنت عم تستخدمه اسمه كاثانون.
نعم.
Yes.
And did you have any authority by way of a lawful prescription or any other authority to use that drug?
وهل كان في عندك صلاحية من خلال روشتة إنك أو أي شيء تاني بيعطيك الصلاحية إنك تستخدم هذا الدواء؟
لا.
No.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes. Yes.
Go ahead, Madam Interpreter.
I'm sorry, Your Honor, I didn't hear you.
Okay. I asked counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
نعم أنا بسأل المحامي إذا أنا اتبعت تعليمات المحكمة أو قوانين المحكمة وهل رح يكون مناسب إني أقبل إقراره بالذنب. الجواب كان نعم.
Yes, Your Honor. Yes, Your Honor.
نعم حضرتك نعم.
The court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
نعم المحكمة رح تقبل إقرار الذنب للتهمة 2. التهمة فقرة 1 رح يتم إلغائها.
A pre-sentence investigation and report and screening assessment is ordered at 14B District Court.
نعم فحص ما قبل الحكم وتقرير وفحص رح يتم تسجيله بالمحكمة 14 B.
Sentencing will be August 29th, 2024 at 10 a.m.
الحكم رح يكون بتاريخ 29/8/2024 الساعة 10 صباحا.
Bond will continue. Thank you.
وسند الكفالة رح يستمر فيه. شكرا.
Thank you, Madam Interpreter. Do appreciate
you.
it. Wonderful
Thank-
job.
Thank you, sir, for using our services. Bye-bye.
Okay, bye-bye. Court does call the case of the people versus Escorcia. Is it Alvarez?
Assistant Public Defender Hannah Apple appearing on behalf of the defendant. Your Honor, I was informed by the jail staff that Mr. Alvarez was released to Immigration Customs on Tuesday.
Ah,
So he is not here.
so Inez has him, or ICE has him.
Yes.
Okay. Well, what I will do is I'll issue a bench warrant for failure to appear, understanding that. On 10,000 cash.
Thank you.
Context to where they're at as you're discussing them, okay? In the first photo here, what are we looking at?
So the photographer would be inside the enclosed porch. That would be the front door leading into the living room. One thing to note here, it's a little bit hazy, but this would be a Ring doorbell that would be mounted on the front of the home.
Okay. And then looking in through that door, can you point out where those pillars are?
Yeah, so this would be the pillar on the north side of the room.
Okay. The next photo here, what are we looking at?
So this is an additional view of the living room. Again, this is the opposite pillar on the south side of the room. You can kind of see into the dining room area. This would be the door to the kitchen. This is a sectional L-shaped couch. Right here is something to note. What we believe to be the family dog was located kind of underneath these blankets.
Kind of wrapped up in
Yeah.
the blanket?
Yeah.
Okay. Okay, this photo, what are we looking at?
So this is, I misspoke, it's not a sectional or L-shaped couch, it's just kind of set up in an L, but this would be the kind of the corner of the home. The couch kind of goes in that L shape. The dog would be located up here. This would be the coffee creamer that Christy Folman brought by for morning coffee and set on that end table.
Okay, and that chair that's next to that table, that's against the wall facing Avoca Street, the front of the home.
Yeah, so this is along the front of the home. This is along the south end of the home.
Okay. All right, what are we looking at in this photo?
Again, these pillars are just going to keep coming up as kind of a frame of reference, but this would be the pillar. This would be our living room. This is the table where the nylon sheath was located. This would be the entrance into that small hallway that gave access to the bedrooms. This would be what we later learned was Jennifer Dazey's purse.
Okay, and if you're in that doorway and you went and you turned right, whose bedroom would you be going to?
Jennifer's.
If you turned left?
Tyler's.
All right. Okay, where are we at here, investigator?
Again, we're back in the dining room. Our table is directly off to right-hand side here into the kitchen. You can't see it, but you can access the basement through a door here, and you kind of access a back like mudroom pantry area through that little opening there.
Okay, do you have any knowledge as to what room Christy Folman was in when officers were there?
My understanding is that she was located in the back of the house here.
Okay, in that pantry type area that you called it?
Mudroom area, yeah.
Okay. What are we looking at here?
This is just an additional view. You'd be standing right next to the refrigerator here. This would be the pantry mudroom and then the exit out of the home. If you walk into this room and take a quick left, that would be the way to exit the residence.
Okay. And then this photo?
Again, that's just the door leading to the outside from the back of the house.
Okay. And here?
So this is a shot into Tyler's bedroom. If you're standing next to the bathroom, which is right here, looking in, this would have been the view of the officers who first encountered Tyler. He would have been laying among these blankets, and he would have been facing the wall there.
Okay. Then here?
This would be if you turned 180 degrees around, you're now looking back down the hallway into Jennifer's room.
Okay, that's the last one on that. I will be putting up more shortly, just so you know, okay? All right, so that was the general layout of the house. When you searched the residence more thoroughly, did you start in the kitchen?
I did.
Tell me about, did you observe anything in the kitchen, anything collected for evidence?
Nothing collected for evidence, sir.
Okay. Observe anything that made you concerned or anything in the kitchen area whatsoever?
No blood evidence in there.
Any signs of a disturbance?
No.
Okay. After the kitchen then, what did you process next?
I believe the next place I went into was the bedroom where Tyler Dazey was located.
Okay, may I approach?
Yes.
12. Handing you what I marked as State's Exhibit 12. It's a group of just 3 photos. What are those photos of?
Photos of Tyler's room.
And that's how it appeared to you on January 18, 2024?
Yep.
Move to admit State's Exhibit 12.
No objection, Your Honor. 12 is admitted.
Okay. The first photo, can you tell me what we're looking at here?
Again, the photographer would be standing in the doorway. This is the makeshift bed. Tyler didn't actually have a bed in his room. He just kind of slept on various blankets and comforters. That's where he would have been located. Right here is the door to the attic, which I mentioned or noted previously.
Okay. And here?
Just an additional view. This is a large Cobalt brand tool chest that he had in his room.
And is there a backpack in there?
There is, yep.
Okay. Did you learn anything about that backpack?
Yeah, so once it came time to actually search the room, search the residence, located, I believe Captain Stile located at least 2 knives in that bag.
Okay, tactical gear, is that what you'd call it?
Yeah.
Okay. And then the next photo?
Again, that's just an additional view of the large cobalt tool chest which he had in his room.
Okay, did you see any blood splatter in that room?
I did not.
Did you see any disturbance of any sort?
No.
And did you locate anything that had identifying information for Tyler Dazey?
I did, yeah.
Tell me about that.
Yeah, it was clear that he was living in the room. There were there in the laundry baskets here. There were numerous shirts from Tri-State Quality Metals that had Tyler embroidered across the chest.
Okay, and was Tyler Dazey's wallet or driver's license also located within the home?
Within the home, yes.
Okay. Did you notice any blood splatter, or did you collect anything from that room?
We did collect some things from that room. We didn't collect any, again, there was no blood spatter within the room, but we did collect certain things from the room. We collected all the blankets that he was kind of using as a makeshift bed that he had kind of been wrapped up when we first came in contact with him.
Did any of those items appear to have any blood on them?
Not that we observed, no.
Okay. So after you went there, did you assist in the search of the bathroom?
I did.
Okay, may I approach?
Yes.
13. Handing you what I previously marked as State's Exhibit 13. Take a look through that group. And what is this a group of photos of?
Just some additional photos of the bathroom.
Okay, and is that how it appeared to you on January 18, 2024?
Yes.
Move to admit State's Exhibit 13.
No objection, Your Honor.
13 is admitted.
Okay, we'll go through these one by one again. Tell me what we're looking at in this photo.
We're just looking into the bathroom from the hallway. We kind of noted that there were several towels that were kind of tossed down on the floor, kicked against the bathtub. Looked like someone had showered and just kind of left the towels there.
Okay, so the shower curtain is obviously where the shower is located.
Yep.
Where is the toilet and sink located if you're looking at this photo?
So it's a really small bathroom. If you walk in and kind of turn off to your right, you're going to locate the sink, and then the toilet's kind of tucked in the corner.
Okay, so the toilet is right behind that door.
Yes.
Okay. All right, what are we looking at here then?
So again, that's the sink. We can see the tub over here. We can see the bathroom over here.
Okay. Does it appear from this that there's some kind of shelf above the toilet?
Yes.
All right, next one.
So this is an additional photo of the shelving unit. If a man stood to use the toilet, they would be kind of facing those shelves. Those shelves would kind of be at varying levels, kind of like shoulder length or shoulder height, head height, stuff like that. This is a SOG brand tactical tomahawk that was resting on the shelves. It was the top part, the actual hatchet was, or the tomahawk was on the shelving unit, but a majority of the actual handle was kind of just left dangling off, almost as though someone had just like quickly set it down and it was right there.
Okay. All right, and then this photo?
So again, it's just an additional photo of how the tactical tomahawk had been set down on top of the shelf. Again, this just kind of better demonstrates how much of that handle was hanging out and how it's almost just like resting on there. And again, the toilet would be directly below it. If a man was standing in front of the toilet to use it, basically you'd get poked with that hatchet the way it was sticking out. It's a very tight squeeze in that bathroom.
Okay, what's that item next to the blade of the hatchet?
So this is just some sort of vape. Again, whether it was nicotine or THC, I don't have an answer to that, but it was some sort of vape device.
Okay. Then here, what are we looking at?
Just an additional photo, again, showing the top of that tactical tomahawk, a better shot of the vape pen, or the vape device.
Okay. So did you collect that hatchet then?
Yeah, the first person into the bathroom actually collected it, but I assisted with the packaging of that hatchet.
Okay, so you assisted with the packaging of the hatchet. What did you do with it after it was packaged?
Once it was packaged, it was set aside for transport to the law enforcement center and then further processing at the state lab.
Okay, at the state crime lab?
Yes.
Okay, and did you package it up and send it to them in its entirety, or did you do any testing on that hatchet first?
No, based off what we were seeing inside the house, we believed there would be some trace evidence on there. When it comes to evidence, kind of the more you kind of handle stuff, tamper with it, move it around, the more likelihood you have of destroying the integrity of that evidence. Something like that, we just want to put it in a box, seal it up, and let someone with even additional training and experience kind of run their tests on there.
So when you sent it to the lab, what kind of testing were you anticipated they would do on this item?
We made some requests for a couple of different kinds of testing. We wanted them to test for DNA and blood evidence, and we also asked that they test for latent fingerprints or anything like that might be on there.
Okay, very good. May I approach?
Yes.
Okay, I'm handing you what I have marked as State's Exhibit 14 and State's Exhibit 15. I'm going to hand you 15 first. What is 15?
So 15 is the SOG brand nylon sheath that keeps being mentioned, which was located on the dining room table.
Okay, and I would move to admit State's Exhibit 15.
No objection.
15 is admitted.
And then 14, I realize I put the sticker on the outside of this evidence box, okay? Tell me what is contained within the box.
So inside that box is a sealed SOG tactical tomahawk, which is sealed in heat seal plastic. Also in there are some swabs which were collected by the DCI laboratory in relation to their testing, which are sealed in a separate package.
Okay, and there's tape and things, you guys always package evidence to ensure the chain of custody, so no foreign hands, so to speak, are on it?
That's correct.
Okay, I would move to admit State's Exhibit 14.
And just look at the box.
Yes, absolutely.
I'm gonna have him open it,
Okay.
so I just didn't want to touch it myself, so I was gonna have him open it. Do you want to see it? Oh, that's fine, we can take the label off. We can put a new label on the inside. Okay.
Your Honor, just for the record, no objection as long as the box doesn't go back.
Exhibit 14 is admitted.
Okay, if you want to open that, investigator, and then when you are done, can the witness step down to show the jury judge?
Yes.
Okay, if you could step down as soon as you're done and bring both items and show them to the jury.
So this would be the tactical tomahawk, which we located in the bathroom. Again, this wasn't how it was initially packaged. It was kind of repackaged for purposes of presentation to you guys today. This would have been what was collected, packaged, and sent to the lab for testing. And then here, Exhibit 15, this again would be that nylon holster, which would have been located on the kitchen table. And again, so it was pretty evident to us that these belong together.
Okay, and then May I approach again, Judge?
Yes.
We'll put the sticker. Okay, and then we'll just put that in that box. Okay. Sorry, just give me 1 second, okay?
Can we take that?
Yes.
Oh, yeah. Okay. So you sent that item in for testing and you continue to process the bathroom. Did you collect any items from the bathroom or any specimens?
Yes, so we, again, we collected that vape. We collected those towels that were kind of balled up on the ground in front of the tub. Because again, it looked as though someone had, the last person who showered may have tossed those down once they were wrapped up. There was a towel hanging on the towel rack, which was also seized. We did seize the shower curtain. There was kind of a pinkish reddish substance on it. Didn't look like it was quite consistent with blood, but whenever we're processing a crime scene, we would rather take more and find out we don't need it, or find out later it wasn't blood than leave evidence at the scene. We also collected a swab from the sink. Inside the sink, there was what looked like a blood droplet on the sink, and so that dried blood would have been collected. We also collected a swab from the area around the bathtub drain. We attempted to remove the drain to kind of access the P-trap to maybe access any trace evidence. We were unable to, so we had to settle for kind of swabbing that area to hopefully collect any trace evidence.
Okay, and you also saw items that you swabbed in the living room and the hallway?
Yes.
Okay. May I approach?
Yes.
Joey. 16 and 17. I'll first hand you State's Exhibit 16. Take a look at those photos.
Yep.
Okay, and what generally is depicted within those photos?
Just kind of the areas that where swabs were collected when we processed the bathroom.
Okay, and then number 17.
Okay.
What are those?
Would have been possible blood spatter, which was located in the living room, dining room, and hallway.
Okay, and these photos looked as the scene did to you on January 18, 2024?
Yes.
Move to admit State's Exhibit 16 and 17.
16 and 17 are both admitted.
May I publish?
Yes.
All right, investigator. You were talking, I believe, about the item depicted in this photo. Can you explain it just again?
So this is the shower curtain. This is kind of that pinkish reddish substance that was on there. We seized the whole curtain just in case, but looking at it closely, it certainly looked much more like maybe nail polish or paint or something than blood. It's just too bright and pink.
Okay. And then here in this photo?
Yeah, so this is the bathroom sink. Placard number 9 marks the dried blood droplet in the sink. That photo is kind of washed out.
Yeah.
I can't point out exactly where that blood droplet is in the photo, but there was one present there, and that was collected.
And it was close somewhere to the drain, right?
Yes.
Okay. And then this one, I'm sorry, these photos are not great. But what's in this one?
That's the bathtub drain. Again, the area that we kind of swabbed was just kind of around there with the hopes of possibly collecting some trace evidence.
Okay. Okay, that's it. And then we'll move on to Exhibit 17.
to report to the supervision officer as directed for the month of April 2024 in violation of condition number 4. How do you plead to that? True or not true?
True.
All right. State, any other allegations to proceed on?
Waive the remaining allegations, Your Honor.
Any objection?
No objection.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, to revoke supervision and assess punishment at 2 years of confinement in the penitentiary.
Is that the agreement?
It is, Your Honor.
And Mr. Bruno, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal? All right, the court will follow your agreement. The court will find violation of condition number 4 true. Court will find you guilty. The court will revoke, assess your sentence at 2 years in the prison, give you credit for any time served. Let's see. All right, is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And as a part of your sentence, I'll suggest the therapeutic community and mental health unit, because I did see that the court had ordered mental health. So the therapeutic community and mental health unit doesn't increase the time that you're in custody, but they may be able to address any issues that you have. So when you're released from prison, you'll be successful. You understand? All right, good luck to you.
Thank you.
You're welcome. Mr. Martinez, are you all ready? And state you may be excused.
Thank you, Your
I'm sorry, I'm just trying to find, yeah. All right, we're back on the record in 2020 CR. I'm sorry.
Sorry, Judge, can I just get his name? I
No,
didn't.
no problem. All right, no problem. We're going to go back on the record in 2020 CR 0123, State of Texas versus Michael Sandoval. And Mr. Martinez, did you have an update for the court?
Yes, Your Honor, I went out in the hallway and the mom did have that number that I need to call. I called and I spoke to an individual by the name of Isaac Garza, and he's supposed to be his boss. And he says, yeah, he has been working for him. And that the good news was that they have a big contract coming up that he claims that he will keep my client busy probably 50, 60 hours minimum per week. So it got verified, Judge.
All right, thank you so much. The court will find you guilty. The court will revoke. The court will follow your agreement, and you're waiving your right to appeal. Is that correct?
That's correct, Judge.
Okay. Court will follow your agreement. The court will sentence you to 100 days in the Bexar County Jail under 1244 and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You could have completed this and not have a felony conviction.
Yes.
Now you have a felony conviction. So as you go through your life, everything that you do from here on out, because you have a child, right?
Yes, ma'am.
You need to ask yourself, am I doing things that will make my child proud to tell other people this is my dad? Am I going to be the father that when there's a father dance or a picnic or whatever is going on, my child is going to run to me because they know who I am and I'm a hard worker for them and I speak with them. You understand?
Yes, ma'am.
Be that parent and don't start smoking any marijuana around your children or smoking marijuana at all. You understand? All right, good luck to you, okay?
Thank you, Your Honor. May I be excused, Your Honor?
Yes.
Thank you, Judge.
All right, who's here on John Arlen Tharnert? Yes. Good morning. If he'll come forward, please. All right, how's it going?
Good. Just
All right.
running around everybody.
Hey, come forward, sir. All right, counsel, where are we on discovery?
We are still working on that and there's a issue with the indictment, but I talked to Mr. Garahan, so we may or may not correct that and we're still going to try and see if we can get it resolved also.
All right, thank you for dressing appropriately for court.
Yes, ma'am.
Ms. Ferguson, this will be the last time for discovery. We're going to recall it in 30 days for a discovery.
Thank you, Judge.
And it's. All right, so we'll be back on August 15th. That will be your discovery date. All right, you're welcome. Once you sign the reset form, you're excused.
August 16 or 15? 15, okay. Thank you.
Thank you,
Have a
Honor.
good day.
You're
Judge.
welcome. Who's here on Stephen Gibson? Good morning. Where's your client?
He's in the back, Judge. He's waiting competency restoration. He last week agreed finally to jail case.
Okay. All right, Ms. Ferguson, on this one, if you can recall this in September. Yes. All right, we're gonna come back on September 12th.
That's fine. Thank you. Judge.
And Norma, on that one, if you can make it a phantom date because he's incompetent. All right,
Getting
thank you.
He's getting better.
That is awesome. Well, maybe they'll restore him.
Well, it's a quick order medication.
Ah, you just never know. Travis Mann.
Morning, Judge.
Good morning, Mr. Mann, come forward. Hello, thank you for dressing appropriately for court.
Thank you.
All right, so today is plea deadline date.
Yes, Judge.
So is it gonna be a jury trial or are you all gonna come to an agreement?
Jury trial, Judge.
All right. Who's the prosecutor? State, how long do you expect this trial to last? It's an evading arrest with a vehicle and attempt to take a weapon from an officer.
Sounds like one or two witnesses, Judge, so not that long, maybe 2 days.
All right, Norma, this is criminal trial division. It's 2 days for trial. And state on this case, both of these cases, if I could get an acknowledgement of discovery?
Yes.
Okay, and so counsel, they'll give you an acknowledgement of discovery and you need to sign that before you leave.
Yes, Judge.
All right, September 3rd will be your jury trial date.
September 3rd.
Yes, they're gonna give you a reset form, so you'll have it.
Thank you, Judge.
You're
Will we
welcome.
be excused after we sign the discovery acknowledgement?
Yes, and after he gets his reset form.
Yes, Judge.
All right, thank you.
Thank you, Your Honor.
You're welcome. Who's here on Carly Green? All right. So jury trial?
Yes, Your Honor.
All right. State, how long do you expect this jury trial to last? This aggravated kidnapping?
This might last a little longer, Judge, 2 to 3 days.
All right.
I agree, 2 to 3 days.
All right, Ms. Ferguson, criminal trial division, jury trial date, 3 days. All right, we'll be back on September 3rd. Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you all will be excused. And I believe I already have the acknowledgement of discovery.
Yes, Your Honor.
All right. All right, thank you.
Thank you, Judge.
All right.
Let's see real quick. We'll get right back to you.
Who's here on Dean Pablo Delgado?
Please be seated, everyone. Okay, a witness for the state, please.
State would call Tara Scott.
Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead and have a seat there. State your name and spell it for the record, please.
Tara, Tara, Scott, Scott.
Go ahead, counsel.
Thank you, Your Honor. What is your present occupation?
I am a criminalist in the DNA section at the Iowa DCI Crime Lab in Ankeny, Iowa.
How long have you been there?
I've been in this position since October of 2007.
May I approach, Your Honor?
Yes.
So it's been marked as State's Exhibit 36. Can you tell me what that document is?
This is my SOQ, or Statement of Qualifications.
Is that a complete and accurate representation of your education, training, and work experience?
Yes.
I'd move to admit Exhibit 36.
Any objection?
No objection.
36 is admitted.
Could you explain just what it is that you do at the laboratory?
So in the DNA casework section, we get evidence that is submitted by police agencies throughout the state. We look at that, we determine if we need to do any screening for body fluids, take samples for DNA, develop DNA profiles, and then compare those to any known DNA profiles that are submitted in that case, write a report to our findings, and then testify if necessary.
Could you explain to the jury just exactly what DNA is?
DNA stands for deoxyribonucleic acid. It is the unit of heredity that is in all cells that have a nucleus in your body. You inherit half your DNA from your mother, half your DNA from your father, and it is shown to be unique except in the case of identical twins.
Where is DNA found?
It is in the nucleus. The nuclear DNA that I test is found in the nucleus of the cells. So it's in blood, seminal fluid, saliva, skin.
How do you examine items for DNA?
Depending on the item and what I'm looking for. If I'm looking for a body fluid, I will do first a visual exam in natural light. If I can't see anything with that, we have alternate light sources that we can use to try to visualize DNA. And then we do a screening test, if applicable, and take a sample from it.
How do you process DNA?
So the cutting that we take, or sample that we take, it goes into a tube, and then we do what's called an extraction, which gets the DNA out of the cells and into a solution. From that, we do what's called a quant that estimates the amount of DNA in the sample. And from that, we perform what's called an amplification that copies that DNA, and then we use a 3500 genetic analyzer to visualize that DNA profile.
What areas of DNA do you test?
There are currently 21 loci or locations on the DNA that we test.
How do you compare DNA found on evidence to a specific individual?
So we use the profile that we develop, and we also develop profiles from known blood or buccal samples, and then we make a comparison based on those two profiles to see if the alleles that are in each loci or location are the same or different.
So on about January 30th of this year, did you receive items from the Dubuque Police Department for testing?
I did.
Did you in fact perform testing?
I did.
Did you author 2 separate reports concerning your testing?
Yes.
May I approach, Your Honor?
Yes.
Show you what's been marked States Exhibit 37 and 38. Could you tell me what those documents are?
37 is the DNA report that was issued on March 4th of 2024. That is my initial report. Item 38, Exhibit 38 is a report I issued on April 3rd of 2024.
Are these both true and accurate copies of your reports?
Yes, they are.
I would move to admit Exhibit 37 and 38.
Any objection?
No objection.
37 and 38 are both admitted.
So if we look at Exhibit 37, on the first page, there's a listing on there. Could you explain what that is?
That is under the heading of items as described by submitting agency. So the list lists the lab number that is assigned once it's submitted, the agency case or agency item number, and then the description that the agency gave us.
And then there's a listing of the items that you tested?
This was all that was submitted. Yes.
Okay. So you didn't necessarily test all of them?
Correct.
Why would you not test some of them?
We tried to look at what would be considered the most probative evidence first, and if we develop profiles from that, don't necessarily look at everything in the case, but we can always go back if requested to.
Your Honor, may I publish Exhibit 37?
Yes.
So of all those items, which ones did you test? Or should I start with which ones did you not?
Let's see here. The ones that I did not examine at that time were the nasal swabs, the right-hand finger clippings, and left-hand finger clippings from Tyler Dazey.
Those would be numbers 2, 3, and 4?
Correct.
And then if you go to the second page on your results of examination, that would explain that?
Yes, on also on items 15 and 16, which were the right-hand fingernail scrapings and left-hand fingernail scrapings from Jennifer Dazey.
Okay, you also did a sexual assault kit?
Yes.
And were there any findings there of significance?
Well, screening did not indicate the presence of seminal fluid on the items, and no sperm were observed, and no DNA factors foreign to Jennifer Dazey were detected in the profiles developed from the epithelial fraction of the oral sample, the epithelial fraction of the anal sample, or the epithelial fraction of the vaginal sample.
So in layman's terms, no significant findings there?
There's nothing foreign to Jennifer Dazey.
Thank you. So then you also looked at items 7 and 8?
Yes.
And these were blood stains from the dining room and from the hallway, is that correct?
That's what they're labeled as, yes.
What were your findings on those specimens?
For item 7, screening indicated the presence of blood on the swabs from dining room, and the DNA profile developed matched the known DNA profile of Jennifer Dazey, and the probability of finding this profile in a population of unrelated individuals chosen at random would be less than 1 out of 310 octillion.
So it's safe to say that the blood belonged to Jennifer Dazey?
Unless she has an identical twin.
And that would be the same for for number 8, 7 and 8 both?
Yes, screening also indicated the presence of blood on the swabs from hallway floor, and the DNA profile developed matched the known of Jennifer Dazey with the same statistic.
Okay, item number 9 was a swab from the bathroom sink. What were your findings on that?
Screening indicated the presence of blood on the swabs from bathroom sink. The DNA profile developed indicated a mixture of 2 individuals, and due to the mixture complexity, no further interpretations can be made.
Could you explain a little bit about what the mixture and complexity mean as it pertains to DNA?
Yes. So when I said you get half your DNA from your mother and half your DNA from your father, so you have 1 or 2 alleles at each location. When you have multiple people, you will see 3 or 4 alleles at each location. When there's not enough difference in the contributors, so if they're about equal or if there's a very low amount, you'll be able to see that you have multiple people, but you won't be able to separate the 2 profiles out.
So in other words, there was DNA there was just a mix and you couldn't pull out any individual people, right?
Correct.
Okay, let's look at item number 10, the hatchet. What were your findings on that?
Screening did not indicate the presence of blood on 2 stains on the blade and head of the hatchet. But screening indicated the presence of blood on 3 areas on the handle of the hatchet.
Did you do that screening for blood, or did someone else?
I did.
When you handled the hatchet, what condition was it in?
I'm not, it was.
Did it appear to have been cleaned or scrubbed or washed?
Not that was obvious, no.
Were there, cakes of mud or dirt or anything on it?
Not that I recall.
Did you find blood on the handle?
Yes.
What were your determinations on that?
Well, I took 1 sample at this time from one of the areas, and the DNA factors detected were too weak for conclusive interpretation.
And again, meaning to lay people?
There's some DNA on there, but there's not enough to determine a profile that is strong enough for comparison.
Okay. Item number 11, you took sample from the bathtub drain. What was your findings there?
Screening indicated the presence of blood on the swabs from bathroom tub drain. The DNA profile developed indicated a mixture of 2 individuals. The profile of the major contributor was consistent with the known DNA profile of Tyler Dazey. The probability of finding this profile in a population of unrelated individuals chosen at random would be less than 1 out of 130 septillion. The additional factors present were insufficient to determine the profile of the minor contributor.
Did you find evidence of blood in the sample that you took from the bathtub drain?
Screening indicated the presence of blood on those swabs, yes.
Was there any testing done to determine whether that was human, animal, or other type of blood?
No, the only thing I did at this time was the DNA testing after that.
Okay, so the DNA testing that you did, you found DNA, but that didn't necessarily come from the blood, did it?
It's possible it came from another source, yes.
So if someone took a shower and shed skin or hair or any other things, that could give up DNA as well, is that right?
Yes.
How does DNA degrade?
So with cleaning products, again, for example, in our lab, we use either alcohol or bleach, a 10% bleach solution to clean between cases and clean our racks and stuff that we put samples in. So that would degrade UV light. So that any other cleaning products, and sometimes time, heat, they can all degrade DNA.
If a person had taken a shower recently, would you think there'd be a better probability of finding DNA as opposed to someone who took a shower a week before in that same tub?
Yes.
All right, let's look at number 12 and 13. We might as well do them together. Those are blood spatters. What were your findings on those?
So for number 12 and 13, screening indicated the presence of blood on the swabs from jewelry box and bedroom wall. The DNA profiles developed matched the known DNA profile of Jennifer Dazey, and the probability of finding this profile in a population of unrelated individuals chosen at random would be less than 1 out of 310 octillion.
So when you get those samples, there may be DNA in a house, for instance, on the wall of someone, right?
That's possible, yes.
And if you have blood on there and you take that sample, is the likelihood of the DNA being in the blood higher than the DNA that would just be pre-existing on the wall before the blood was there?
Yes.
So it would be very unlikely to take a sample of blood and find that the primary contributor was the person whose DNA was on the wall to begin with, if that makes sense.
Yes, I think it would be more likely in this for blood on a wall when you take a sample for the DNA profile, especially a single source, to be from the blood as opposed to background DNA that's on the wall.
So the blood would be the primary one, as you've been talking about, right?
Yes.
And there may be other DNA mixed in, but it's going to be minimal.
In most circumstances, yes.
All right, let's look at Exhibit 38. Yes. May I publish Exhibit 38, Your Honor?
Yes.
And again, on this one, we've got 4 items listed. Did you test all 4 of those?
I did.
And this was a follow-up testing?
Yes.
You did later? Why did you do a follow-up testing?
I spoke with somebody from the Butte Police Department and they requested additional testing.
Okay, so let's look at 3 and 4. What were those?
3, the screening did not indicate the presence of blood on the right-hand fingernail clippings from Tyler Dazey, and the DNA factors detected from swabs of the right-hand fingernail clippings from Tyler Dazey were too weak for conclusive interpretation.
That would not be uncommon, would it?
No.
In taking fingernail clippings?
That's not uncommon, no.
How about item number 10?
The screening indicated the presence of blood on 2 areas of the handle of the hatchet. No DNA profile was developed from swabs of the area on the SOG side of the hatchet handle. The DNA profile developed from swabs of the area under the S on the hatchet handle indicated a mixture of 2 individuals. The profile of the major contributor was consistent with the known DNA profile of Jennifer Dazey. The probability of finding this profile in a population of unrelated individuals chosen at random would be less than 1 out of 2.5 octillion.
May I approach, Your Honor?
Yes.
And you what's been marked Exhibit 14. Is that the same hatchet that you examined?
Yes, it is.
Can you see your marks on there?
Yes, I can.
Could you show the jury where you did the testing on there?
On this side, under the blade side on the handle, is where you can see I've circled it, and I have 10.1 listed. 10.2 is adjacent to that on the adjacent side of the handle. And then 10.3 is a small stain here under where it says the SOG here on the towards the bottom half of the handle. And that's where I circled and tested that area.
So when you say under the S, that means below it on the handle, not actually under it.
Correct.
So your findings on 2 of those did not show any DNA, or you couldn't get a profile, is that right? Or am I misreading that?
Yes. So in 10.1, the DNA factors detected were too weak. 10.2 did not develop a profile. And so yeah, if that answers your question.
Yes. Okay. And 10.3 is where you did develop that profile.
Correct.
And again, that was Jennifer Dazey?
The major contributor, yes.
Yes. And you had another individual there, but that was not enough to develop the profile, is that right?
Right. There was one additional factor present that was insufficient to determine the profile of the minor contributor.
Did you take swabs of the blade of that hatchet at some point?
Yes.
What did you find from that?
Screening did not indicate the presence of blood on the blade of the hatchet, and the DNA factors detected from swabs of the blade of the hatchet were too weak for conclusive interpretation.
Could that be that there may have been blood on there which had been scrubbed or wiped away and left some DNA but not enough to make a profile?
That's possible.
Did you find any actual blood on that weapon when you tested it?
The 3 areas that screen positive for the presence of blood.
But that wasn't visible to the naked eye, was it?
No, they were small and dilute stains.
Yeah, so you had to test for that just to pull it out of there? Would it be safe to say that this weapon had been cleaned of blood at some point, leaving only that little bit of residue behind?
That's outside my area of expertise.
Fair enough. I don't have any further questions.
Cross-examination. I've got it.
Yes.
Now, and you just testified about that in some detail, didn't you?
Yes.
Okay. So let's talk a little bit about a few of these things. One of the things I want to ask you about is sources of DNA. Blood is one source of DNA, isn't it?
Yes.
What other sources of DNA are there?
Saliva, skin cells, seminal fluid.
Okay. We excrete DNA pretty much all the time, don't we?
I'm not sure what you mean by excrete.
Well, for example, there's even some small amount of DNA in the moisture in my breath, isn't there?
Yes, that would be from the skin cells inside your mouth.
And when I touch something, if I'm the type of person who leaves DNA, I would leave DNA on pretty much anything and everything I touch.
Potentially.
And the longer I'm in an area, for example, if we're talking about my bedroom, or we're talking about an item that I handle on a regular basis, like a jewelry box, I could leave a lot of DNA on those items, couldn't I?
You could.
If I've been living in a location for a number of years, those skin cells can actually accumulate, can't they?
Yes.
And I understand there's some degradation, but depending on the level of cleaning and what's used to clean. And we can clean with some things and it doesn't really affect the DNA, isn't that right?
Yes.
Now, let's talk about a few of the items up here. I understand that initially you did not test items 2, 3, and 4. Is that right?
Correct.
Okay, so we'll talk about those when we get over to State's Exhibit 38. The first thing I want to talk about is item number 7. Now, this is reported as being a swab from a possible blood stain in the dining room.
Yes.
Okay. And I believe we heard, well, I believe on direct examination, you testified that you were able to develop a DNA profile from that?
Yes.
And that the swab tested positive for blood. Is that right?
Screening indicated the presence of blood, yes.
And I just want to make sure that I heard you correctly. Did you say that that was Jennifer Dazey's blood?
I did not.
If you did say that, that's actually more than you can say, isn't it?
Yes.
Okay. You can't say that that's Jennifer Dazey's blood, can you?
No, I can only say that the profile developed from that swab matches her.
Okay. And that's for a couple of different reasons. Number one, did you test item 7 to determine if it was human or animal blood?
I did not do that test, no.
Were you aware that there was animal blood in the area?
Yes,
Okay. But you didn't test to determine whether or not the blood stain in item 7 was human or animal blood.
correct, I did not.
And as I understand it, when you swab an area, especially if it's wet, for example, if I touch a table and I walk away, but if I get that wet with something and I swab it then, doesn't that actually increase the number of skin cells and stuff that I'm going to pull off of that item that I'm swabbing? Potentially, if there's skin cells there.
Okay.
If there's DNA, touch DNA on that item, and I then moisten it a little bit, and then I swab it, I'm going to get the moisture, but I'm also going to get the touch DNA, aren't I?
You could potentially, if there's some there, yes.
Okay. And the fact that it's moist might actually increase the likelihood that I get that touch DNA, doesn't it?
I'm not sure how to answer that question.
Well, let me ask you this. Do you know if the DNA profile that you detected, and I understand it was Jennifer Dazey's DNA to the 310 octillion or something like that. Is that right?
If the statistic, yes.
Okay. Do you know whether or not that DNA came from the blood, or did it come from skin cells or touch DNA that was located in that same area that was swabbed?
That cannot be determined.
And the likelihood of whether or not it came from one or the other would depend on whether or not that was animal or human blood to some extent, wouldn't it?
Technically, yes.
Because if it was animal blood, you're not getting human DNA from it, right?
Correct.
It would also depend to some extent on how much exposure to her DNA that location on the floor had had, wouldn't it?
Technically, yes.
All right. And that's essentially why you're not able to tell us whether or not item 7, even though it tested positive for blood, you're not able to tell us whether or not that was Jennifer Dazey's blood,
Correct.
are you?
I cannot say that, correct.
Okay. Is it fair to say that you would expect to find touch DNA and, well, essentially touch DNA or skin cell DNA from other DNA sources for someone where they live?
In some areas more than others, but yes, in the areas that they live.
Okay. Well, let's talk about some of these. Number 8 is a swab from a possible blood stain in a hallway. Did you screen to see, well, let me ask you this. Did you screen to determine whether blood was present?
Yes.
Okay. Did you screen to determine whether it was human or animal blood?
I did not.
Were you able to develop a DNA profile?
Yes.
Do you know whether or not that DNA profile came from the blood, or could it have come from other touch DNA located on the swab?
I cannot say with any certainty that it came, or with any, I cannot say for sure whether it came from the blood, no.
Okay. And it would not be unusual to find Jennifer Dazey's DNA on the hallway floor right outside her bedroom in a house where she's lived for several years, would it?
On a general floor in a house, I would not necessarily expect to find that a large amount of DNA. So is it possible? Yes.
Okay. Did you find a large amount of DNA?
I'd have to refer to my notes to see what the estimate of that was.
Okay. Let's talk about item 9, which is the swab from a possible blood stain in the bathroom sink. Did you screen that swab for blood?
Yes.
And was there blood present?
Screening indicated the presence of blood, yes.
Did you test to see whether or not that was human or animal blood?
I did not.
Were you able to develop a DNA profile?
There was DNA factors detected, yes.
Okay. Were you able to develop a profile?
I'm not sure what you mean by develop a profile.
Were you able to determine whose DNA it was?
No, I was not able to determine whose DNA it was.
All right. Sorry, they have our computers on a timer. With regards to, we'll skip item 10 because for the moment, with regards to item 11, that's the swab from around the bathtub drain, and I think you testified about that. It's on direct examination?
Yes.
Okay. You would expect to find a lot of different sources of DNA in a bathtub drain, wouldn't you?
There are potentially a lot of sources, yes.
Okay. Now, this was swabbed. You didn't actually see the drain. You just saw the swab from the drain, right?
Correct. I saw only the swab.
Okay. Were you able, did you screen the swab for blood?
Yes.
Okay. Did the screening test positive for blood?
The screening indicated the presence of blood, yes.
Did you test whether or not that was human or animal blood?
I did not.
And I apologize because, I mean, obviously you know what my next question is on each of these, but we still need to go slow so that she can take it all down. We can't talk at the same time. Were you able to develop a DNA profile?
Yes.
And whose DNA profile were you able to develop?
There was a mixture of DNA on this, and the profile of the major contributor was consistent with the known of Tyler Dazey.
Now, are you able to say that that's Tyler Dazey's blood?
No, I am not.
Okay. And that's because the DNA profile could have come from, well, skin cell DNA or hair DNA or any of the other sources of DNA that you would find in a bathtub drain.
Potentially, yes.
And you would expect to find somebody's DNA in the bathtub drain where they tend to bathe, wouldn't you?
I would say it would not be an unexpected finding to find their DNA there.
Okay. Item number 12. This is an interesting one. Item number 12 is a swab from possible blood stain on the top of the jewelry box in the bedroom. Is that right?
That's what it was listed as, yes.
Okay. You didn't actually see this jewelry box, you just saw the swab.
Correct. I only saw the swab.
Did you screen the swab for blood?
I did.
And did it test positive for blood?
Screening indicated the presence of blood on the swabs from jewelry box.
Did you test to see whether it was human or animal blood?
I did not.
Were you able to develop a DNA profile from the swab?
Yes.
And whose DNA profile were you able to develop from the swab?
The DNA profile developed matched the known of Jennifer Dazey.
Now, and this may seem silly, but you're not actually able to say that that DNA profile came from the blood, are you?
No, I cannot say that.
So you can't actually even say that that's Jennifer Dazey's blood, can you?
I cannot say that.
Moving on to item number 13. That was a swab collected from a blood stain on a bedroom wall. And I understand your testimony on direct examination was that...
An unexpected finding either.
Okay. Was item number 13 tested to determine whether or not there was blood present?
Yes, it was.
And what was the result of the test?
Screening indicated the presence of blood on the swabs from bedroom wall.
Did you test to see whether or not it was animal or human blood?
No, I did not.
Were you able to develop a DNA profile from the swab?
Yes, I was.
And as I understand it, that was Jennifer Dazey's DNA?
Correct.
Are you able to tell us whether or not that DNA came from the blood on the swab, or did it come, or could it have come from other sources of touch DNA on the swab?
I cannot say.
So you're not able to actually tell us whether or not that blood is Jennifer Dazey's blood either?
I cannot say that.
Let's move to State's Exhibit number 38. And I put that up there on the screen for you as well. The state didn't really talk about this one, but I think I want to talk about it just to emphasize the point. Item number 2, that was a nasal swab collected actually from Tyler Dazey, wasn't it?
That's what it was listed as, yes.
Okay. And you would expect to find Tyler Dazey's DNA in his nose, wouldn't you?
Yes.
Okay. It would be in the mucus in his nose. He's got hair in his nose. I mean, all those different sources.
Mucus and skin cells, yes.
Okay. Now, when you tested that, did you test it for the presence of blood?
I did.
Did it test positive for blood?
Screening indicated the presence of blood on the nasal swabs from Tyler Dazey.
Okay. Did you test that to determine whether or not it was human or animal blood?
I did not.
Were you able to develop a DNA profile from that?
Yes, I was.
And whose DNA profile were you able to find in the swab?
So there is no DNA factors foreign to Tyler Dazey in the profile developed from the nasal swabs.
So you found Tyler Dazey's DNA in the swab?
Yes.
Okay. But interestingly enough, you're not able to say that that was Tyler Dazey's blood, are you?
I am not.
And that would be for the same reasons we've discussed before, isn't it?
Yes.
Let's talk about item 10. All right. I understand that you screened two additional, item 10, you initially screened one area. Is that right?
I initially screened 3 areas.
Okay.
Actually, on the handle only?
Right.
Okay, so there's 3 areas on the handle that I screened initially.
when I look back at, when you screened those 3 areas initially, what did you find in your report dated March 4th?
Screening indicated the presence of blood on 3 areas of the handle of the hatchet.
Okay. As I understand it, at that time, you only tested 1 for DNA?
Correct.
Okay. And that would be the one that's marked on the hatchet as 10.1?
Yes.
Okay. Did you find any DNA factors at that time?
Yes.
Were you able to develop a DNA profile?
The DNA factors were too weak for conclusive interpretation.
Did you test to determine whether or not that was human or animal blood?
10.1, I did not.
And I think you said that you also tested the blade and head of the hatchet?
Correct.
But you didn't find blood on the blade or head of the hatchet?
Yes. Screening did not indicate the presence of blood on blade and head of the hatchet.
Now, looking at exhibit number 38, your report dated April 3rd. You then tested 2 more spots on the hatchet, as I understand it, 10.2 and 10.3. Is that right?
Yes.
Now, as I understand it, these 2 areas had already tested positive for the presence of blood?
Yes. Screening indicated the presence of blood on those 2 areas.
Did you test to determine whether or not it was animal or human blood?
Yes.
Okay. And what were you able to determine?
It was human blood.
All right.
The screening test indicated.
For both 10.2 and 10.3?
Yes.
All right. And were you able to develop, as I understand it, a DNA profile on only 10.3?
Yes.
And that was the DNA profile of Jennifer Dazey?
The major contributor was, yes.
Okay. And there was a minor contributor who wasn't identifiable?
Correct.
Were you able to detect any DNA on the blade of the hatchet?
Yes.
And I know you testified on direct examination a little bit about this, but the fact that you were able to detect DNA on the blade of the hatchet what does that indicate with regards to the likelihood that the hatchet was washed or cleaned or scrubbed?
I can't say. That's outside my area of expertise. I can't say whether that indicates or does not indicate cleaning.
But you actually did find touch DNA, is what it would have to be, right?
I can't say the source of the DNA. I can just say it did not screen. The screening test did not indicate the presence of blood.
But there was DNA on the blade of the hatchet?
Yes.
Were you able to develop a profile?
There were factors detected, but not enough to make any interpretation.
With regards to the DNA profile that you developed on 10.3, all right, are you able to say definitively that that came from the blood?
No.
So you're not able to say whether or not that was Jennifer Dazey's blood?
I cannot say that.
Were you ever asked to test a shower curtain?
No.
Nothing further.
Mr. Nelson?
Thank you, Your Honor. You're a scientist, aren't you?
Yes.
You can't say much of anything in the scientific world with absolute certainty, can you?
No.
So when you're answering these questions today about certainty, that's sort of where you're coming from, isn't it?
Yes.
Absolute certainty. But in many cases, you can say there's a very high likelihood, couldn't you?
Yes.
So if you take swabs of blood off the floor and off of the jewelry box on the wall, it is possible to get other DNA, correct?
Correct.
But isn't blood usually swabbed because it's a very good source of DNA?
Yes.
So when you take a blood swab off of a wall or jewelry box or any other item, wouldn't you expect that to be the dominant contributor when you're testing for DNA, as opposed to background DNA that might have been there before?
In most cases, yes.
When you do a blood screen, that's just a test for blood or not blood, isn't it?
Correct.
And for the most part, it doesn't test for human or animal, it's just blood, right?
For those screening tests, it's just whether or not it is blood.
If you tested animal blood, would you expect to find animal DNA?
With the testing that I do, we only detect human DNA.
So if it were animal blood, you wouldn't detect anything based on your testing, correct?
I would not get a profile from animal blood with the testing that I do.
If you had animal blood, you're probably not going to get a DNA profile of Jennifer Dazey from that, are you?
It would not come from animal blood if it was her profile, correct?
Thank you. I don't have anything further.
Mr. Blair?
That's kind of a misleading question, though, isn't it? Because the swab doesn't just have the blood on it, does it?
I don't know what the swab has on it, besides that it's screened positive for blood.
Right. And if it is animal blood and you detect human DNA, that human DNA would have had to have come from some other source, right?
Yes, if it was animal blood and a human DNA profile, it would have had to come from some other source.
Okay. So when you say that blood is a dominant contributor for human DNA, only human blood is a dominant contributor for human DNA.
Yes.
And that's the problem, is that if you haven't determined whether or not it's human or animal blood, you don't know whether or not the human DNA came from the blood or from some other source of DNA.
I can't say with certainty that a profile from blood swab does not have any other sources of DNA in it.
And that's one of the reasons why you're not able to tell us whether or not any of the blood is actually Jennifer Dazey's blood, isn't it?
I cannot say with certainty that the profiles I developed from the swabs are her blood, no.
Not just with, well, not even a reasonable degree of certainty, are you?
There's no statistic or studies that I'm aware of that have tried to determine a number to put to that or a degree of certainty.
Okay. Nothing further.
Not to beat dead horses, but you can't say with absolute certainty, but you can say with a pretty high likelihood, can't you?
Yes, we do use known blood samples taken from a person to develop known profiles. So I know that you can get DNA from blood and the white blood cells that are in blood. I can't give a real number or certainty to if it was another source.
Thank you. Nothing further.
Okay, thank you, ma'am. You're free to go.
Thank you.
Okay, perfect spot for us to break for lunch. Remember the admonition I've given you before. Report back to the jury room. We'll try to start up again around 1:20.
How do you plead to that? True or not true?
True.
All right. State, any other allegations to proceed on?
Waive the remaining allegations, Your Honor.
Any objection?
No objection.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, to revoke supervision and assess punishment at 2 years of confinement in the penitentiary.
Is that the agreement?
It is, Your Honor.
And Mr. Bruno, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal? All right, the court will follow your agreement. The court will find violation of condition number 4 true. Court will find you guilty. The court will revoke, assess your sentence at 2 years in the prison, give you credit for any time served. Let's see. All right, is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And as a part of your sentence, I'll suggest the therapeutic community and mental health unit, because I did see that the court had ordered mental health. So the therapeutic community and mental health unit doesn't increase the time that you're in custody, but they may be able to address any issues that you have. So when you're released from prison, you'll be successful. You understand? All right, good luck to you.
Thank you.
You're welcome. Mr. Martinez, are you all ready? And state you may be excused.
Thank you, Your
I'm sorry, I'm just trying to find, yeah. All right, we're back on the record in 2020 CR. I'm sorry.
Sorry, Judge, can I just get his name? I
No,
didn't.
no problem. All right, no problem. We're going to go back on the record in 2020 CR 0123, State of Texas versus Michael Sandoval. And Mr. Martinez, did you have an update for the court?
Yes, Your Honor, I went out in the hallway and the mom did have that number that I need to call. I called and I spoke to an individual by the name of Isaac Garza, and he's supposed to be his boss. And he says, yeah, he has been working for him. And that the good news was that they have a big contract coming up that he claims that he will keep my client busy probably 50, 60 hour minimum per week. So it got verified, Judge.
All right, thank you so much. The court will find you guilty. The court will revoke. The court will follow your agreement, and you're waiving your right to appeal. Is that correct?
That's correct, Judge.
Okay. Court will follow your agreement. The court will sentence you to 100 days in the Bexar County Jail under 1244 and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You could have completed this and not have a felony conviction.
Yes.
Now you have a felony conviction. So as you go through your life, everything that you do from here on out, because you have a child, right?
Yes, ma'am.
You need to ask yourself, am I doing things that will make my child proud to tell other people this is my dad? Am I going to be the father that when there's a father dance or a picnic or whatever is going on, my child is going to run to me because they know who I am and I'm a hard worker for them and I speak with them. You understand?
Yes, ma'am.
Be that parent and don't start smoking any marijuana around your children or smoking marijuana at all. You understand? All right, good luck to you, okay?
Thank you, Your Honor. May I be excused, Your Honor?
Yes.
Thank you, Judge.
All right, who's here on John Arlen Tharnert? Yes.
Good morning.
Good morning. If he'll come forward, please.
How you been, Judge?
All right, how's it going?
Good. Just
All right.
running around everybody.
Hey, come forward, sir. All right, counsel, where are we on discovery?
We are still working on that, and there's a issue with the indictment, but I talked to Mr. Garahan, so we may or may not correct that, and we're still going to try and see if we can get it resolved also.
All right. Thank you for dressing appropriately for court.
Yes, ma'am.
Ms. Ferguson, this will be the last time for discovery. We're going to recall it in 30 days for a discovery.
Thank you, Judge.
And it's, all right, so we'll be back on August 15th.
Thank
That
you,
will be
Your
your discovery date.
Appreciate that.
All right, you're welcome. Once you sign the reset form, you are excused.
Yes, ma'am.
August 16 or 15? 15, okay. Thank you.
Thank you, Your
Have a
Honor.
good day,
You're
Judge.
welcome. Who's here on Stephen Gibson?
Yeah.
Good morning. Where's your client?
He's in the back, Judge. He's awaiting competency restoration. He last week agreed finally to jail case.
Okay. All right, Ms. Ferguson, on this one, if you can recall this in September. Yes. All right, we're going to come back on September 12th.
That's fine. Thank you, Judge.
And Norma, on that one, if you can make it a phantom date because he's incompetent. All right, thank you.
He's getting better.
That is awesome. Well, maybe they'll restore him.
Well, it's a quick order medication.
Ah, you just never know. Travis Mann.
Morning, Judge.
Good morning, Mr. Mann, come forward. Hello, thank you for dressing appropriately for court.
Thank you.
All right, so today is plea deadline date.
Yes, Judge.
So is it going to be a jury trial or are you all going to come to an agreement?
Jury trial, Judge.
All right. Who's the prosecutor? Jade, how long do you expect this trial to last? It's an evading arrest with a vehicle and attempt to take a weapon from an officer.
Sounds like 1 or 2 witnesses, Judge, so not that long, maybe 2 days.
All right, Norma, this is criminal trial division. It's 2 days for trial. And state on this case, both of these cases, if I could get an acknowledgement of discovery?
Yes.
Okay. And so counsel, they'll give you an acknowledgement of discovery and you need to sign that before you leave.
Yes, Judge.
All right, September 3rd will be your jury trial date.
September 3rd.
Yes, they're gonna give you a reset form, so you'll have it.
Thank you, Judge.
You're
Will we
welcome.
be excused after we sign the discovery acknowledgement?
Yes, and after he gets his reset form.
Yes, Judge.
All right, thank you.
Thank you, Your Honor.
You're welcome. Who's here on Carly Green? All right. So jury trial?
Yes, Your Honor.
All right. State, how long do you expect this jury trial to last? This aggravated kidnapping?
This might last a little longer, Judge, 2 to 3 days.
All right.
I agree, 2 to 3 days.
All right, Ms. Ferguson, criminal trial division, jury trial date, 3 days. All right, we'll be back on September 3rd. Thank you for dressing appropriately for court and being on time. All right, once you sign the reset form, you all will be excused. And I believe I already have the acknowledgement of discovery.
Yes, Your Honor.
All right. All right, thank you.
Thank you, Judge.
All right.
I'll see you real quick. We'll get right back to you.
Who's here on Dean Pablo Delgado?
I am, Your Honor. Yeah.
Yes.
This is a bond hearing, Your Honor.
Okay.
Your Honor, I have the bond motion.
Oh, I have it.
You got,
Yes.
okay, just want to
But
make that sure.
I like when people have that because you never know. It goes missing. All right, and have you conferred with the state on a possible agreement to the motion or no?
Yes, I have,
Okay.
for one of the motions, Your Honor.
Okay, there's 2 motions?
There are 2 motions.
Ah. Well, I may need that. The only motion I have is a motion to set bond.
I'll give both.
All right, thank you.
One is the CM, we haven't
Really
discussed the CM, but we did discuss the DC.
Let me find him on the docket. All right. Court is going to call for purposes of setting a bond, 2022 CR 3996 and CM 114252, State of Texas versus Dean Pablo Delgado. Can I have parties announced for the record for the state
Andrew Harris, Saban.
defense?
Ron Zimmerman for Mr. Delgado.
All right, and there's a request for bond in each of these cause numbers. The first bond request for the 2022 CR 3996, the defendant is on deferred adjudication. He's entitled to a bond and he's on deferred adjudication for the state jail felony on authorized use of a vehicle. Is there a proposed agreement for a bond amount?
Yes, there is, Your Honor.
Yes.
7,000, Your Honor.
That is the agreement, Your Honor.
All right. For the record, the court is aware of the defendant's history based upon the fact that the defendant is on deferred adjudication out of this court. However, since he's been in custody, I just want to make sure there are no updates that the court needs. Mr. Delgado, can you raise your right hand for the court, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Delgado.
All right, since you've been at the Bear County Jail, are you on any type of medications for mental health issues? All right. Have you ever had any mental health issues? All right, then with regards to the bond, the court will follow your agreement and in that cause number, set the bond at $7,000. Mr. Delgado, do you have a place to live? And who you'll be living with? All right, I'm gonna need you all to write the address in this document and I'll let you have a chance to speak with him in private to write the address down.
Okay, thank you, Your Honor.
All right, now in regards to CM 114252, is there a proposed bond agreement?
There is no agreement in this one, Your Honor.
There's not an agreement on this.
All right, defense, what are you requesting?
I'm requesting $3,000 bond.
All right, state, what are you requesting?
15,000, Your Honor.
All right, and all right, there's a wide gap between what's being requested. So if we'll start with you, defense, it's your motion. Why are you requesting a $3,000 bond?
Well, Your Honor, the bond has not been set. In my opinion, I have looked at the underlying crime that he is accused of committing on this case. And I feel that his participation in the theft of the firearm is fairly limited, Your Honor. And in addition, Mr. Delgado, when he found out that there was a warrant, this offense date was in 2023. When he found out that there was a warrant on this case, he did voluntarily go to the jail and submit for custody.
All right, and counsel, the only bond that, if you have the separate bond paperwork, please give it to me, but I see that we're just here on the CM 114252, and I'm assuming he has a bond on the CM 114250.
Yes, he does, Your Honor.
All right, and what is that bond amount in that case?
That is 15,000, Your Honor.
All right, and state you're requesting 15,000?
Correct, Your Honor.
Okay, and why?
On the basis that while Mr. Pablo Delgado was on supervision for an offense he is accused of committing to others, that the magistrate court judge saw fit to set his bond in one of those cases at 15,000. It stands to reason that his bond should be the same in an offense that arises out of the same criminal episode.
All right, so in that cause number, this is what the court will do. And Mr. Delgado, I want to let you know that I've heard what your attorney has said. I've heard what the state has said, and I'm looking at the fact that you are currently on probation. And the cases that you're alleged to have committed while you were on probation are theft of a vehicle and theft of a firearm. And I understand what your counsel is saying about the facts and the theft of the firearm. Court is going to set your bond and the CM number at $10,000, and the court is going to order full GPS and waive the fees.
Thank you.
And you're to reside with your mother and defense counsel. If you write the address to them in that motion, please.
Yes, I will, Your Honor.
All right, next, we're off the record. We need a date for this for a contested hearing. Counsel, do you have the discovery on the CM numbers?
On both of them, not quite, Your Honor. I haven't seen the videos on this,
All right.
Your Honor, but the state did provide me the written report from the police department, Your Honor.
All right.
And I believe, Your Honor, if I may, I believe the contested hearing is set for August 1st.
Yes.
Yes.
All right, so we're going to keep the August 1st date. Is there anything else from either side?
State, Your Honor.
Not this time, Your Honor.
All right, we'll close the record. Thank you.
All right, thank you, Your Honor.
May I be excused, Your Honor?
Yes.
Thank you.
And Ms. Ferguson, if you'll give him an August, thank you. Yes. And he'll provide you with that motion with his client's address. Ramon Sanchez. Good morning. All right, today is your plea deadline date. This-
Yes, there's a discovery issue that I
All
want
right, what is the discovery issue?
I checked the website yesterday,
Mhm.
and reviewed discovery, and I had not received the medical reports. This is an assault on a public servant.
Okay,
And I checked yesterday and I didn't find anything except a one-page discharge form. But I see that there are medical reports in the file, which I reviewed very briefly. And what I'm asking is a 2-week reset for them to put the medical reports into the system so I can review them with my client, and then I'll come back with it.
all right, and those, the medical reports that you have in the file?
Yes, those are the medical reports.
So those, that's the entirety of the medical reports.
Yes.
Let me see how many pages is that? Not that many,
I know it's about that many. I'd say it's about 100 pages.
100 pages. State. Hi, is anyone able to just go upstairs and print out this medical report for defense counsel? Is that possible?
I do not know, Your Honor.
Okay. Because he's saying he's waiting for the medical records to be uploaded, and I know there are some issues with Odyssey. So,
Your Honor, if the medical records were included with the case file when it was indicted, then it should have already been uploaded, which leads me to believe that the problem is not that the documents have not been uploaded, but that defense counsel cannot access them, in which case the better course of action would be to take the scanned documents, convert them to a disk to make available to defense counsel.
all right.
I could bring a flash drive tomorrow,
Okay,
bring it to the DA, we could make a copy, it'd be fine.
okay. All right, Ms. Ferguson, if you can recall this case and let me see. If you can recall it the second week in August, and that will be your final plea deadline date.
Thank you, Your Honor.
Okay. All right, August 12th.
Fine, thank you very
All
much.
right, thank you. Aiden Martinez. Hello.
How you doing, Judge?
All right, how are you doing this morning?
I am doing good.
My allergies are not doing well today, though, but
It's almost Friday, so
hey, it is Friday Eve, which is always a good thing. All right, so where are we on labs?
the labs are in, Judge.
Okay.
So Judge, if I could just express some concerns of mine to the court.
Yes.
The lab results came in. I
Mhm.
retrieved them earlier this week.
Mhm.
The file was so big that they could not download it to the e-discovery. So it was on a disk. I went to go retrieve the disk. And to my surprise, it's like 2,500 pages.
2,500 pages.
It's about 2,500 pages.
Like of Shakespeare's work.
It's huge. I've started going through some of it.
It's
and
the
then
War and Peace of drug testing.
And my head just started spinning, Judge, just.
War
from
and
the-
Peace of drug testing on marijuana.
Yeah. So, a couple of things I want to.
Anna Karenina.
Yeah. A couple of things I want to express to the court. Since 2019.
The English Patient.
Yeah.
You know, I'm just thinking of long movies and long things.
Since 2019, once the marijuana, the law.
Yeah.
In reference to marijuana changed, I have not had to try one of these cases. I don't think anybody has had to try any of these cases. And I am trying to make sure I have everything straight
Mhm.
before I can properly advise my client.
All right, let me ask this. State, were you able to tender an offer?
There is an offer, there is an offer on the table.
All right, so this is what we're gonna do. We're gonna recall this in 45 days, and that will be your plea deadline date.
Okay. One more thing, Judge. If we do lean towards trying this case, again, through the association, Criminal Defense Lawyers Association, nobody's had to try any of these cases since like 2019.
Are you giving the state hints? Nobody's
No.
ever had to try these.
No.
You know, it's the infamous, when we would have clients who had driving while license invalid, they would be like, nobody's ever tried these cases.
Well,
And nobody would. Something would always happen.
well, I'm not gonna say nobody's tried any of these cases. What I am saying is, when I put the question out there, who's had to try when nobody responds? So that just means that
Maybe they're
whoever's.
just not looking at their emails.
Yeah. So Judge, this is the other thing I'd like for you to consider. Just in case we figure out that we do have to try this case,
Mhm.
I would like to try to get ahead of the game and ask the court. I don't know if you've had to try one recently in your court, but if you,
Nobody ever tries these cases.
if you have a standard jury charge that without hearing any of the evidence, the standard base jury charge that you would probably use, if your charge writer could give me a copy of that.
Mhm.
And that's gonna also assist me in reviewing the
Sure.
scientific information, and I could properly advise him on which way I think we should go.
Okay.
The other thing is this, Judge, and the last thing, and I know you've already said it, but I would ask if you would be a little patient with me, a little patient with Jason, and maybe not give us the 45-day deadline, because you did make me a generous offer.
Mhm.
I'm just covering myself before I
You know what,
do
you're
that.
taking me back to my Sunday school days where they would have everybody sing, be patient with me, God isn't through with me yet. But
And,
no,
and,
I mean,
and I've been working diligently towards this.
Well, no,
and
no, no,
so
we'll
has
see where
Jason.
we are in 45 days will be a plea deadline date. We'll see where we are in 45 days. Okay?
Will do.
All right.
Thank you, Judge. And then
You're so welcome.
when can I get back to you in reference to that, a jury charge?
Probably next week.
Next week? Thank you, Judge. I appreciate
I'll
it.
look over it. Yes.
Okay.
All right, thank you. Once you sign the reset form, you'll be excused. Ms. Ferguson, I need a 45-day reset. And it's on Aiden Taylor Martinez. He's on page 2. All right, September 3rd. You know how that week is gonna go. Because that first day is on. Okay, I'm sorry, I put it out there, didn't I? It's gonna be fabulous. He's on page 2. Zach is looking at me like, is there any way we can unput it out there?
Your Honor, may I?
Yes.
A rejection for Ms. Lewis.
Right, thank you.
Her case, not her personal.
All right,
Thank you.
thank you. Oh, and Norma, did the attorney turn in that motion with the defendant's address where he will be staying?
Yes.
Okay, awesome. Israel Medellin. Everyone, the court is taking its recess at 12. If your client has not been here, you need to pick up the phone. I'm sorry, if your attorney's not been here, you need to pick up the phone and call them. Oh, I've already signed it.
Oh, okay.
No problem. We're doing a lot. It's a lot of moving parts today.
I'll keep that in mind.
Oh, for this one. Now there's that.
Mr. Juarez, we're still waiting for your attorney to come.
He texted me, he said he was coming.
Well, he didn't notify me, so I'll them to notify her.
All right, thank you.
Oh my gosh, look at all these. Wow, Jack.
Deputy Laura, this is, wow. This is so awesome, and they smell so great. I am telling you, you never know what your day is gonna bring, right? You just have to be ready and assume that it's gonna be happiness and joy. Yeah. And I'm like, oh, that is so beautiful. And you know, I'm ready for a relationship because you know, the flowers. Just 1 second. right, Mr. Pettis. So I went next door to see what is happening with your case as far as being in the mental health court.
Yes,
So there are two people that you and your attorney are going to need to contact.
okay,
But I'm going to reset you. And I'm going to reset you for 30 days. But the way the mental health court works, if they accept you, your case will go to the mental health court. You won't be in court here anymore.
okay, okay,
All right. So, but the date I'm giving you is going to be 30 days and it will be here.
okay,
If you show up here and you need to be in mental health court, then we'll send you to mental health court.
okay.
But you need to make sure you show up here. You understand?
Yes,
All right, Ms. Ferguson, on that, if I can have a 30-day reset. All right, so we're going to bring you back on August 19th.
okay,
And Ms. Ferguson is going to give you the contact information for those two persons, and your attorney will have it as well through email.
thank you, Judge.
All right, you're welcome. Thank you for dressing appropriately for court.
Thank you, you look great too, so.
All right, well, you have a great day. I
You
tell
too.
you what, it's looking stormy
It
outside.
is, oh no.
Oh, yeah, it's very dark outside.
We keep safe also. I don't have a raincoat, but I think you probably do have a raincoat.
Well, no, I have an umbrella. I always
That's good.
carry an
That's even
umbrella.
better.
Yes. All right.
All right, thank you. Have a good day.
All right, well, once they get you a reset form, you'll be excused,
All
okay?
right, yes. I'll sit down right now and they can send you.
And Norma, what page is he on? All right, thank you. Oh, it's under Frank Pettis? Okay. All right, it's gonna be Romero, Guzman, and then it will be Simmons after that. And then after that, it will be Moody and Juarez. All right, are you okay, Mr. Guzman? All right, court is calling 2024 CR 6742, State of Texas versus Romero Guzman. Can I have parties announced for the record for the state?
Andrew Harris Salem.
Defense?
Roberto Ambrosino.
Are you Mr. Guzman?
Yes, ma'am.
All right, counsel, have you received all of the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Guzman, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do. We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that you're charged with the offense of fraudulent use of possession of identifying information less than 5 items as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sure.
Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Guzman, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's $1,000 fine to be probated and the state recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There have not.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, and no contact with Shalisa, Thomas, and Anna Chavez. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No causes.
State any evidence.
Contained in Exhibit 1 and attachments, Your Honor.
No objection.
All right. State you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Would just like to ask the court to follow the plea bargain agreement. He's been in for 4 months, so he's had some time to reflect on the situation and I think he's contrite.
All right, how old are you?
23.
Do you have any children?
No, no.
Do you have any family support?
No, not.
All right, why do you say no, not right now? Who would be your family support? Where are your parents?
My dad, I think he's in state jail right now, and my mom, I had bad terms with her the last time I spoke to her. We ended on bad terms.
All right, and what's the tattoo across your head? What's that about?
That's my mom.
Okay. So was Child Protective Services ever involved in your life when you were a child?
Yes, ma'am.
All right, do you know why?
I was told multiple stories, neglect, abuse.
Okay. So how often were you using drugs when you were not in custody?
I was doing a lot.
Okay, and what were you using?
Methamphetamine, marijuana.
And do you have a place to stay?
Not at the moment, no.
Have you ever had employment?
Yes.
Doing what?
Construction work.
Okay. And when's the first time you started using?
I started using marijuana at like 12 and methamphetamine. I just started like last year.
Okay. How far did you go in school?
11th grade.
Right. Why did you only go to the 11th grade?
I aged out of CPS and I was on the streets and I had to worry about everything else that I was going through.
Okay. So what are your hopes and your dreams as far as employment?
I want to be an entrepreneur and get into real estate, help people. That's it.
Okay. Well, I will tell you, people will always say, that dream is not realistic. But I know someone who went to felony drug court and everybody was telling them, not realistic that you can be an attorney. And guess what? That person is a licensed attorney. So I will tell you what you want to do. It can be done, but you just made it harder for yourself to get that done. You understand? So if you really want to do it, you're going to have to really work hard. All right. This is what I'm going to do. I'm going to find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 4 years. If he completes everything early, then he can always come back. I'm going to do a referral to felony drug court. I think that's the best place for him. They'll help him with housing and give him some sort of stability. That evaluation is going to take place while you're in custody. Since tomorrow is Friday, they'll probably be able to see you Monday, and they will let me know whether or not you've been accepted by Tuesday. I want you to be 100% honest with them, because you're not going to be able to make it on probation on your own. And when I say on your own, it's up to you, of course, but you're not going to be able to make it if you don't have the tools to remain clean and sober, because where you are in your life right now is you don't have a place to stay. You have 11th grade education. You don't have any family support. It's just you in the world on your own. And that's not good when you have drug problems on top of that. Do you understand? All right.
Judge,
Yes.
would the court consider deferred adjudication? And the reason I ask is because the state was actually offering that, the term was going to be longer, but since the term is longer anyway, my guess is they wouldn't have any objection to it.
Do you mind if I join this conversation?
Yes.
Yeah, please.
All right. So I know that outside the agreement, you all asked for 3 years community supervision. I'm going to give him 4 years community supervision. Defense counsel is now saying, could they receive deferred?
That was our initial offer, Your Honor.
All right.
For deferred, I don't think he wanted to do the extra year, but if he's doing the extra year, then we might as well.
All right. So with the deferred adjudication, what that means is if you complete it successfully, the case is going to show up on your record, but it will show that you were placed on deferred adjudication and there will be no conviction. But the downside to deferred, which you're already facing that downside anyway, is that the full range of punishment is open to the court. So would you like for the court to place you on deferred?
Yes, Your Honor.
All right. So
Interviewed me, said they were going to send her that to see if she accept the recommendation.
Okay, I guess he's been interviewed by Lifetime Recovery.
all right.
it's
So
something
what
he's
will
up
end
for.
up, happening with that? Felony drug court will interview you, and felony drug court may say the best placement for you is Lifetime. But honestly, I think you need something more stringent than Lifetime based upon your drug use. And where you are in your life today, it's not saying that this is where you're going to end up. But I want you to get the conditions you need in order for you to be clean and healthy. All right, so it's going to be 4 years deferred adjudication, referral to felony drug court in custody. If not accepted, then TAP evaluation in custody. Follow TAP recommendations. There is to be no contact with Shalisa Thomas, Anna Chavez, and I'm going to add the location of the offense. And the reason why I'm adding that, Mr. Guzman, is because they did a trespass warning against you. So if you show up, you can be arrested because they've already given you a no trespass warning. You understand?
Yes, ma'am.
So there's to be no contact with 8719 Warsbach Road, San Antonio, Texas 78240. There's to be regular reporting by Zoom or in person. There's to be the UA hotline until further notice. 120 sober meetings in 120 days, field visits, 1 time per month until further notice, proof of employment within 60 days of release. There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. That will be waived if you complete some sort of higher education course, if you complete a trade school, or if you obtain your GED. Probation, is there anything else he needs? All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because, oh, I'm sorry, I'm not sure files. I think they have it. All right, we can go off the record. Here's the thing. In this court, to be successful in probation, communication is key. Communicate with your probation officer. If you feel as though they're not addressing the issues you're coming to them with, you can always come back to this court and address them with me. I'm here from Monday through Friday, not on weekends or holidays. If a felony drug court accepts you and you graduate, I will make sure I come to your graduation. And this is something that you really, really need, okay? All right, good luck to you. You're welcome. And what page? All right, you too.
May it please the court. As the court will remember, the state gave a brief statement of facts at the guilty plea back in June. So I would like to take a moment to give a little bit of a more detailed version of facts. I've prepared these in a PowerPoint, but I did bring physical printouts of some of the images I've used, if the court would like those as well.
Well, I'll just look online for now.
Yes, sir. I wanted to start kind of with an overview of the different locations that are involved in this case. Starting with up here, which is Heritage Park, which is where the vehicle was found. And the vehicle was found on Saturday, November 11th of 2022, November 12th of 2022. It was found at 10:41 a.m. by an officer of the Rome Police Department. The vehicle is a Toyota Prius. It had gone into a ditch that is in the part of Heritage Park near where it reaches the river. And that Toyota Prius belonged to Randy Davis, Aaron Davis, the victim's father. Aaron was using the vehicle at that time. The car was found around 10:41. Officers responded, and it was initially just to a suspicious vehicle. But quickly they were able to get in touch with Randy Davis, who let them know that his son had been using the vehicle, and it turned into a missing persons case pretty quickly from that. The case would then evolve where officers who had heard that the defendant had been on scene in Heritage Park where the car was and had given a brief statement to officers there. They heard about that and decided to do a follow-up. So these officers traveled to the defendant's residence in Old East Rome off of Collingwood Drive in order to make contact with him. They did so a little after 2 p.m. in the afternoon that day. they received consent to search the home and pretty quickly found what they believed to be a crime scene of a serious nature due to the amount of blood. They also found cleaning supplies, and when they opened the washer where there were bloody sheets inside, the defendant fled from the residence at that point. That was after around 2:30 is when he fled in the afternoon on that Saturday. In less than 10 hours from when the car was found by police that morning, the murder scene had been identified, the defendant was in custody, and the body had been recovered. Around 7:30 p.m. that evening, Jeremy Reisner, the defendant's father, called law enforcement to let them know that the defendant was going to turn himself in. Jeremy went with him, and at that time, Jeremy Reisner gave the location of Aaron's body. And Aaron's body was off of Tumlin Drive down here. Tumlin Drive dead ends at a church. And there's as you can see around this, there's a very dense wooded area around the church. And his body was recovered in that wooded area. And I did have just a few brief pictures of each scene. Here's an image from a police camera of the vehicle as it was found partially submerged in this creek. This is a creek in Heritage Park that does run towards the river. Once they pulled the vehicle out of the water, they were able to see what appeared to be blood stains and was later confirmed by the GBI to be not only blood, but Aaron's blood inside the vehicle. This is Aaron's own vehicle. Also within the vehicle was a backpack that was filled with bricks. These bricks had a St. Joe marker on them, and later those bricks were found both inside and outside the defendant's residence. And then this is for the back of the vehicle. So Aaron's own vehicle was used to transport Aaron's body. This is the upstairs bedroom at the defendant's residence where Aaron was staying that night. And the defendant had already begun cleaning it. Up here is a large patch of what turned out to be blood spatter and blood that the defendant had attempted to clean off of the roof area of the bedroom. And there was also blood spatter throughout here as well. And some of these were in various stages of being cleaned. And then here's a close-up of some of that had not been cleaned yet, and it was also all over that panoramic picture. So we were looking at the bed just now, and the ceiling with the spatter was about here. This is another shot. This room is the bathroom. It goes to that room. There's a TV over here, and as you can see, there are numerous cleaning products over here and even on the bed as well, and the bed has been stripped of sheets and the comforter. This shows just a wider angle of that, so you can see the cleaning supplies and things that are being taken there. And I'll ask you just kind of notice this piece of furniture, because we're about to see a close-up of that area that you can identify based on the furniture. And so here, all through here, is blood that had cleaning supplies and other things dumped on it. Aaron was killed on the bed, as you from the different blood above the bed and things of that nature, and then drug into the bathroom. His blood was found on the door of the bathroom shower in there, as well as in other places. And there's a significant amount of blood that had pooled here because they cut the carpet, and then you can see that it had already sunk through the different layers and into the subfloor. And then this is that shower that I mentioned where Aaron's blood was found both inside and on the door handle leading to the shower. This is how officers found it. So these gloves belong to the defendant, and he must have worn them at some point in either his cleanup or his attempted dismemberment. This is a fallen tree root ball in the woods off of Tumlin Drive. Like I mentioned earlier, there's a church at the dead end, and it's surrounded by woods. If you go into those woods a little bit There is this tree bulb, and there's kind of a crevice here. This is where officers were able to uncover the body of Aaron Davis. You can see that they're kind of down into that crevice, and they're beginning to uncover him here. He was wrapped in the sheets and comforter from that upstairs bedroom. He was also wrapped in duct tape as well. That duct tape the defendant had purchased at Walmart after the murder, and his fingerprints were on it. I did want to talk about the injuries to Aaron because they were significant, and I believe that there's certainly evidence of aggravating circumstances. So a total of 40 stab wounds, 6 to his head, 4 to his neck, 21 to the torso, 2 to the left upper extremity, and 7 to the right upper extremity. There was also attempted dismemberment around his abdomen and around one of his arms and shoulder area, but we believe that the dismemberment happened after. I do have a few photos, not many, just to show some of these injuries because I'm going to talk about the level of hemorrhage associated with the injuries. So this is the front and back of Aaron. The injuries have been labeled by the medical examiner with the letter system. And I did want to, there's significant injuries to the neck, both in the front and the back. There are also injuries down along this side. Those begin with I and go into JKL. And I'll show a different angle of those later. But I also want to highlight that there are not injuries on Aaron's hands. Aaron didn't have any defensive wounds. Aaron didn't see this coming. Aaron didn't defend himself. This was not a case of mutual combat or anything like that. He does not have any defensive marks on his hands. Here's a side view of those wounds that I mentioned, I, J, K, L, M, and N. And I'm going to put up a diagram now that shows these injuries, but on a drawing instead of the autopsy photos. So this is color-coded. Pink means that there is hemorrhage, and what hemorrhage indicates is that Aaron's heart was beating, and so his blood was pumping through his body. So those injuries that I talked about on the side over here that we saw a picture of a moment ago, those all have pink. So his heart was beating, his blood was pumping. Also those neck injuries that I pointed out, same thing, on here and here and here. A pink meaning his heart was beating. Most of the colors on here are pink. The orange means minimal hemorrhage. It means that the level of hemorrhage was less, most likely because the heart was beating less, or it was beating slower. In other words, Aaron was dying at that point. So orange means he was still alive, but his heartbeat was weaker and slower. No color on the chart means that there was no hemorrhage. It doesn't necessarily mean post-mortem, but it does mean that his heart wasn't beating at a level to cause a hemorrhage. Most of the marks on here are color-coded. And what that means is that Aaron was alive when this happened. And for the majority of these horrific wounds, Aaron's heart was beating and there was hemorrhage and he was alive. And then the next level of wounds shows again the orange hemorrhage, meaning his heartbeat was slower, it was weaker at that point. I will point out that these shaded areas are parts of the dismemberment that we saw in the autopsy photos as well. And again, that is believed to have happened post-mortem or after Aaron's death. Also, part of the autopsy, a portion of the small intestine was missing, and it's believed that it was removed through this area of dismemberment there. In contrast to the significant injuries Aaron had, these are the only marks that were on the defendant. A scrape or scratch here on his side, and and then a cut on his pinky finger. And it may be a little bit hard to see on the screen, but there is some type of bruising on on the defendant's knuckles. I submit to you that those injuries were incurred by the defendant in the attack. Again, this is not a situation of mutual combat. This is not a situation where Aaron fought back. The defendant was the only aggressor and the only person offering violence when this happened. I next want to talk about some of the steps the defendant took to try to cover up this crime after it happened. Charlie Girl Schellinger is the girlfriend of Aaron, and Aaron was actually on his way to see her, and he was just stopping in Rome at his best friend's house on the way to go see her. It was unusual for Aaron and Charlie Girl not to communicate frequently. And so when she had not heard from him, and the last time she heard from him was in the early evening of Thursday the 10th. When she still hadn't heard from Aaron the next day, she then reaches out to Brandon because she knows that that's where Aaron had been staying. And he starts telling her, you know, he's with me, but his phone is dead, talks about telling him, or, you know, they're on a walk right now, he still hasn't charged it, stuff like that. At this point, Aaron is dead. And what the defendant is doing is lying and attempting to cover up his crime. And then it gets to a level where she is continuing to be persistent. And so this is on the 11th, excuse me, this one might be the 12th. But she is still kind of wondering what's going on. And here's where the defendant comes up with a new story that Aaron has gone home to Cumming, Georgia to get a Switch, which is presumably a Nintendo Switch, a type of game, and that he is then going to go to Alabama the next day. So that is what he is explaining as to where Aaron could be or why Aaron is no longer responding. He then begins to sort of feign concern, and that he too hasn't heard from Aaron, things like that. And at one point he even tells her that he's going to start looking, and he actually does do that. He does show up at Heritage Park, feigning concern for Aaron and offering to try to help join into the search for Aaron. Of course, he's only offering to start looking after Charlie Girl has let him know that she and her family are on the way to Rome to start the search for themselves. I also want to talk about his internet searches in the time. So November 10th, they start here and go this way. He searches for Cosmic Dog Outpost. We know that that's where he took Aaron on Thursday night. They were at Cosmic Dog for about an hour, around 7:45. The defendant ordered drinks for them. He ordered two different, they each had 2 beers, but they were high content alcohol beers. And that's significant because Aaron was not a drinker. It was part of his faith, so it was not something that Aaron did frequently. And the defendant ordered very high alcohol content drinks for them both, and he paid. And so we just know this kind of just indicate he had looked up Cosmic Dog, and they do ultimately go there. We know that they go after Cosmic Dog to Giggity's, where the defendant again pays and orders drinks from them. And after that, they return to the defendant's residence. I'll talk a little bit more about that later, but I want to continue on with the internet searches. So in this one, and these start over here and go in this direction. So this is on November 11th, Friday. At this point, Aaron is dead. The defendant has already killed Aaron. And he is searching over and over for sheets and blankets. More than 20 searches for sheets and blankets. What he's trying to do is find a replacement for the sheets and blanket that Aaron is ultimately going to be buried in. He's trying to find a replacement set so that the bedroom will appear unchanged, and again to cover up his crime. These are his searches on that day continued. And I'll highlight just a few of them. Professional stain remover. Does Walmart have duct tape? Schizophrenia symptoms. Hydrochloric acid. best secluded locations, how to drain wash.
Okay, do we have a witness for the state?
Yes, Your Honor, we would call Kurt Rosenthal.
Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Go ahead and have a seat there. State your name and spell it for the record, please.
Kurt, K-U-R-T, Rosenthal, R-O-S-E-N-T-H-A-L.
Mr. Nelson.
Thank you, Your Honor. What is your current employment?
The City of Dubuque Police Department.
How long have you been so employed?
I will have 22 years on this September.
What are your present duties?
I am an investigator with the Criminal Investigation Division.
How long have you been there?
I'll be back there for 5 years come this September.
Do you have any special training and qualifications required to do your job?
I've been through multiple trainings over my career specific to CID. I've been to crime scene schools, interview and interrogation, homicide school, and countless others.
Do you have certain trainings and certifications that are required as part of your employment?
Yes, sir.
Are you up to date on all of that?
I am.
On January 18th of this year, were you called to 1605 Avoca Street?
Yes, sir.
What was the nature of that call?
Shortly after 8:50 in the morning, we were alerted of a suspicious death call at 1605 Avoca. We gathered up in the office. At that point in time, we were advised that the decedent was Jennifer Dazey, and it appeared that it was a homicide.
Did you respond to that alone, or did you go with somebody?
No, at 9:03 that morning, Corporal Hoff and I got in a car together and traveled up to Avoca, arrived on scene about 9:10.
When you arrived at the scene, what did you do?
As soon as we got on scene, we were advised that the initial person who found Miss Dazey had encountered her son, Tyler Dazey, inside the residence, and we believed that he was still inside. So at that time, I went to the south side of the residence as part of the perimeter.
Were there other officers also securing the perimeter?
Yes, sir, there was multiple officers on scene.
What do you do when you take the perimeter?
We're just covering points of exit, make sure somebody doesn't run out the back door or jump out a window.
You're also looking so nobody goes in while officers are clearing?
Absolutely.
Do you also check for signs of forced entry?
Yes, but based on where I was located, that really wasn't a duty of mine.
At some point, did you learn that the house was cleared and someone was in custody?
Yes, I heard radio traffic from one of the patrol officers inside that they had one in custody.
What did you do at that point?
At that point in time, I circled around to the front of the residence, and at the front door, I came in contact with my captain, Captain Style. He had already been inside, kind of briefed me on the injuries that he observed, and noted that Tyler Dazey was in fact the person they had in custody. At that point in time, we kind of decided who was going to do what moving forward, and I was tasked with trying to interview Mr. Dazey at the Law Enforcement Center. And then Corporal Stair was going outside to get a Tyvek suit so that we could dress Mr. Dazey, and that's when I entered the residence.
What did you observe when you entered the residence?
I walked through the living room and to the north portion of the house where the two bedrooms were. As I got in that area to my left in the west bedroom, I saw Officer Slight down on a knee, and he had secured Mr. Dazey, who was face down on the ground and was naked. Corporal Leck was also in that room. At that time, another officer on scene directed me back to the living room to point out Echo, the dog, dead on the couch. I then returned back to the area of the bedrooms. I peered into the east bedroom, and I could see that Miss Dazey was clearly deceased in her bed. I took a few steps into that room. I was only in the room for maybe 15 seconds, but I was able to note the severe lacerations to her head and face. There was pooling of blood near her right side of her neck, and I could also see that she had a couple fingers severed on her left hand. I backed out, and then I went back into the west bedroom where Mr. Dazey was being secured.
Did you observe a toolbox in that bedroom?
I did. Inside of that bedroom, there was a large black and blue toolbox on wheels like a mechanic would have in their shop.
At some point along the way, this is be much later than being at the house, we'll come back here, but did you have any involvement in tracking Kylie Frey's movements around on January 17th and January 18th?
I did later in the investigation.
How did you go about doing that, and what was the purpose?
I don't know if anybody spoke of this yet, but I think we have over 1,000 traffic cameras within the city of Dubuque. Pretty much every main intersection in town is covered. The downtown area, there's pretty much every single corner is covered. So I utilized traffic camera footage to track her movements throughout the 17th and the early hours of the 18th. At the time, Kylie was residing in the 2400 block of Jackson. There is a bank of cameras right at 24th and Jackson. So I started reviewing those from the morning of the 17th, and I was able to track her movements all the way until she comes to the scene on Avoca after police were already on scene.
Why were you tracking her movements via those cameras?
As part of any investigation, especially in a homicide, not only are we looking for evidence to identify possible suspects, we're also trying to exclude potential suspects. So in this case, we're just following up on her statements she gave to other officers about her whereabouts.
So when you start an investigation, it's kind of a broad net you throw out. You don't get a narrow focus and pick a couple people and only investigate them?
No, even in this case, day one, we arrest our suspect, but that doesn't end the work. There could be other people that were potentially involved. New information could come in, so we want to get on that early, try to figure out who is all involved in this family, friends of Jennifer, see what they had going on in the days leading up.
Do you know if Nick Frey was also tracked on cameras?
Yes, I believe that was tasked with Investigator Hoff.
And that's a common thing to do on any investigation, is that right?
It is.
After doing all of that, well, let me ask you this. Are you familiar with a Life 360 application for phones?
I have a general idea of what it is.
Were you provided with data on that from Kylie Frey?
Yes, Lieutenant Crable on January 19th had met with Kylie, and she provided her Life 360 data from her phone to Crable.
Did you end up with that data?
I did. After I had tracked Kylie over those 2 days on traffic cameras, then I reviewed the Life 360. I didn't look at that prior to. I wanted to have a clean slate, so I didn't miss anything when I was reviewing it. And those two, when I looked at them side by side, mirrored one another.
By the way, how long did it take you to review all those traffic cameras and track her on those days?
Well, I first pick her up on the morning of the 17th, leaving her residence about 9:25, and then I watch her until just short of 11 a.m. the next day. I have her at home throughout the night, Wednesday night into Thursday. I watched that camera throughout the entire night. So it took me hours to watch that 26 hours of footage.
Did you at some point compare the data from that Life 360 to what you found in your review of traffic cameras?
Yes, I noted they mirrored one another.
In all respects?
Sorry.
That was in all respects?
Yes, the Life 360, the first data, the oldest data that was provided to Crable was Wednesday afternoon around the 3:30 hour. So obviously I had more details as far as her movements. I had her from early that morning.
So you didn't see anybody leave the residence all night, the night of the 17th into the 18th?
No, she gets dropped off. She works at the Village Inn on JFK. She gets dropped off by a coworker right about 10:30. They stop right in the middle of the street in a white Nissan SUV. I can see Kylie get out of the passenger seat and then walk to her residence. I watched the entirety of that night on Jackson Street, and the next time I see her is right before 8 o'clock. She steps outside of her residence, gets in a cab. That cab drives her directly to the Village Inn. She goes back to work. She's there at 8:05, and the next movements I see from her is when Jennifer's neighbor, Jill Risselman, she picks her up in a green Jeep about 10:52 in the morning, and she drives her direct to the neighborhood on Avoca, showing up there about 11 o'clock.
And did that 360 data match up with that?
Yes, it did.
It showed that she never left her residence the entire night?
Correct. It shows her arriving at home from work on Wednesday evening, being home until I see her get in that cab and leave the next morning.
Now, in terms of possibilities, would it be possible for her to have slipped out the back door and evaded the traffic cameras and left her phone at home?
There's possible, and there's probable. Is it possible? But we have absolutely zero evidence showing that she ever left the residence.
Okay, now at some point in your investigation, you had contact with Tyler Dazey, is that correct?
Correct. When I entered the bedroom, when I was first on scene while we were waiting someone to bring in a Tyvek suit.
Did you have anything to do with putting on the Tyvek suit? Did you assist?
Well, I did. I zipped it up.
What's the purpose of a Tyvek suit?
In this case, it was to preserve any possible evidence that was contained on Tyler or Mr. Dazey's body, specifically if there was any blood, hairs, or DNA from Jennifer.
And that has little boots that go with it as well?
Correct. It's all one piece.
Did you make any observations about Mr. Dazey at that time?
Your Honor, I'm going to object, knowing where this is going, pursuant to Iowa Rules of Evidence 5.401, 5.402, and 5.403.
Okay, the objection's overruled. Go ahead, ask the question, Mr. Nelson.
Did you make any observations about Mr. Dazey at that time?
Well, the first thing I noted was his erection. But then once we got him onto his feet, he had a blank stare on his face. He was moving slowly, lethargically, but he was following our commands.
Did you have any conversations with Mr. Dazey at that time?
Not really a conversation. I introduced myself. I told him that he wasn't being placed under arrest, but he was being detained, and that we were going to be transporting him to the law enforcement center where we would talk to him down there. I asked him if he understood. He didn't respond audibly, but he did nod to me.
Did you end up taking him to the hospital first?
We ended up shifting gears, and eventually Officer Hesselbacher and I would transport him to Mercy.
Why did you decide to take him to the hospital?
Based on how he was acting, we were concerned that he may have ingested some kind of substance before police arrival, and we wanted to make sure that his vitals were stable and that he was medically cleared before we took any further steps in the investigation.
What happened when you got to the hospital?
We entered the ER with Mr. Dazey. Staff directed us to the behavioral health room because it wasn't so much he didn't have any traumatic injuries or anything that needed to be dealt with right away. Hesselbacher took him into that room. I met with staff just to explain to them the purpose of us being there and what we needed from them.
Was staff familiar with him?
Yes, one of the nurses specifically was familiar with Mr. Dazey.
Was Mr. Dazey examined?
He was by both nurses and the ER doctor.
What was the result of that examination to the extent you know?
They advised me that his vitals were all stable, he was cognizant, and that they would be clearing him medically.
Okay, so while you were at the hospital, was there any decisions made regarding search warrants?
There was, prior to us ever leaving Avoca, we knew that we would be applying at this time for at least 2 search warrants, one for the house on Avoca and one for Tyler Dazey's person to collect any potential evidence. I contacted Captain Style, my captain, and then Hoff, who was working on the search warrant applications, to see what we specifically wanted to apply for, what we wanted to gather. And it was at that time we decided we wanted to collect specimens of his urine and his blood to go along with other items.
Did you stay at the hospital pending that warrant?
Yes, I advised hospital staff that we were going to hang tight there because we can't draw blood. We would have, we need the techs up there to do that. So we just stayed up there awaiting approval for the search warrant from the judge.
Was the warrant approved ultimately?
It was.
While you were waiting for the warrants, did you have any conversations with Mr. Dazey?
I did, and it was specific to the search warrant. Both Hoff and I assumed that Mr. Dazey lived at 1605 Avoca, but I had not confirmed that with him. So after my conversation with Hoff, I walked back into the BH room and I asked Mr. Dazey if he resided on Avoca. He just shrugged his shoulders. I then asked him if he normally stayed at his mom's residence, if that was his normal residence. His response was, "Whose mom?" I then asked him, "Is Jennifer Dazey your mother?" And his response to that question was pretentious.
Did you feel he was just being obstinate with you at that time?
Absolutely.
Objection, Your Honor, calls for speculation.
And it's leading, sustained.
At some point, did Mr. Dazey indicate he needed to use the bathroom?
Yeah, that was roughly about 25 minutes after we got to the ER. He advised that he needed to urinate. I knew that we were working on getting a search warrant to collect his urine, so I asked him if he could just hold tight. We had some processing to do. That's when he stated to me, "I'm letting go, the keys are yours." I again asked him, "Hang tight for me, we need to collect." That's when I told him, "We're going to collect your urine." He then said, "I gotta pee." Again, I urged him to just hold on for a couple minutes. He then leaned back in the sofa that he was seated on, and I could hear him urinating inside the Tyvek suit.
Did he do that more than once?
Multiple times while we were at the hospital.
Did at one point you tell him that he could have held it?
I did. I was a little disturbed that a grown man wouldn't hold his urine for a couple minutes, and his answer to that was, "Wars are meant to be fought."
Did you try to collect a sample at one point when he was urinating?
Yes, approximately an hour later, we had already secured the search warrant. I had advised Mercy staff that we were ready to do the collection. They were outside our room just getting their gear ready to go. I walked back in the room. Mr. Dazey advised that he had to urinate again. At this point in time, he had crawled down on the floor, asked if I could help him up. I helped him up off the floor. I told him, "Hey, you don't have to pee in your suit this time. Staff's going to walk in any minute. We'll have you urinate into a cup." Within seconds, staff walks in, and as they walk through the front door or walk into the door of the room, I hear him urinating in his suit again. I scrambled to try to unzip his suit and asked one of the nurses to bring over a collection cup. By the time that happens, we got just a very small sample.
Did you have another effort at collecting a sample?
Yeah, approximately 40 minutes later, Skrupski and I had, Officer Skrupski and I had transported Mr. Dazey from Mercy back down to the law enforcement center. I was at my desk. Skrupski was in the interview room with Dazey, just awaiting me to get prepared to come in and start interviewing him. Skrupski told me that he had to urinate again, so I asked Skrupski to escort Mr. Dazey to the bathroom, and I had a collection cup with me. We met in there. Again, I had unzipped his Tyvek suit to expose him. At that point in time, he thought that he felt as though he needed to urinate, but he didn't know if he could and thought it might be a couple seconds. He then stated, "I'm not trying to dick you around." I told him, "Hey, we got time. We'll just sit here. Let me know when you need to go." Within a matter of seconds, he said, "Quantum entanglement, brother," and he started urinating. I was only a step away with the cup. I was able to reach into his stream and got a proper sample.
What was his demeanor at that time?
Completely cognizant, like he's telling me, hey, I'm not trying to mess with you here. I got to pee, but it's going to take me a second. He was, in my opinion, completely aware of what was happening.
At some point, did you observe and photograph Mr. Dazey?
Yes, as part of the search warrant execution, which we did after the interview, a part of that we took photos. I took photos of his person. During that time, I noted some abrasions on the backside of his right hand, 2 on his index finger, 1 on this middle knuckle, and 1 on this knuckle, and then a 3rd abrasion to his ring finger, middle knuckle.
May I approach, Your Honor?
Yes.
Show you what's been marked with State's Exhibit number 41. You recognize that photograph?
Yes, I do. I took that photo.
I would move to have Exhibit 41 admitted.
Any objection?
Your Honor, I'm going to object pursuant to 5.403. I think that photograph is just flat out inappropriate.
Is what?
Just flat out inappropriate.
Let me view it, please.
Permission to approach?
Yes. Okay, State's Exhibit 41 is admitted.
Yes. May I publish, Your Honor?
Yes. I don't think you're plugged in.
Were you able to identify the person that you took the photo of?
Yes, that is a photo of Mr. Tyler Dazey.
And you positively identified him as such?
Correct.
And is he the same Tyler Dazey that is the defendant in this case before the court today?
Yes, he is.
Now, you can take that down. Did you interview Mr. Dazey at the law enforcement center?
Yes. Corporal Gorell and I interviewed him at 12:01 p.m. that afternoon in a recorded interview room in our CID offices.
Did you ask him about his sleep from the day before, the night before?
I did. That is a question that I regularly ask most people that I interview, just their normal sleep patterns. And I asked Mr. Dazey specifically how much sleep he had gotten the night before. He advised that he didn't get much sleep, upwards to maybe an hour at the most.
Did you also ask him when he last showered?
I did. I asked him about his bathing habits, and he advised that he used the shower in the main floor bathroom. He advised that he had taken one shower the evening before after he had a workout. He ballparked that to be around 8 p.m., and then he advised he had taken another shower just prior to police coming into his home that morning. And that is why he was naked.
Did you ask him if he owns a hatchet?
I did. Mr. Dazey acknowledged that he did own a hatchet. He advised me that he kept that hatchet in his toolbox within his bedroom, and he also noted that he had actually observed that hatchet that morning.
Did Mr. Dazey make any statements concerning his discipline and awareness of surroundings?
There were multiple times during the interview where he stressed how disciplined he was and how he was very aware of everything around him and what was happening.
Did you ask any questions about the layout of the house?
I did, and as soon as I asked that question, he said, "You were there." So he was obviously recognized I was in the room with him earlier that morning.
Did you ask him about his relationship with his mother?
I did. His response was, "It's fine, except for when she's acting sneaky like a witch." He then went on to talk about how his mother was part of a covenant of witches. I also asked, I followed that up with how he thought his mom thought of him. And his answer to that question was, "I think she hated me so much that she hated herself."
Did you ask when he last had a conversation with his mother?
Yes, he advised that was just before police came in and got him, and at the time she was practicing witchcraft.
Did he say where that conversation took place?
Yes, he stated that his mother was in her bed, again, noting that she was practicing witchcraft.
Did you ask about specific events that morning?
I did multiple times throughout the interview, early on when I tried to hone in on what he was doing in the minutes, the hours before police arrived. He would either say that he didn't remember or he would shift topic. Then toward the end of the interview, I again asked him what he could specifically recall happening before police got there. And he said that he was having a conversation in his head that he did not want to think about. This conversation was about trauma. He didn't want to think about it, and he would not expand on that when I asked him what that conversation was.
Did you ask him about his mom's witchcraft?
We went into that in a little more detail. He described her witchcraft as putting evil on him. He said just evil. I then asked him how he felt about his mother practicing witchcraft. And I think that is when he gets into stating something similar to, I just gave up. I just don't care. I don't need her to validate me. He then followed that comment up with, why would I care what a whore thinks? You sit around and drink yourself stupid, fuck like animals, and ruin your children's lives. Why would I care what a person like that thinks?
Did he say anything about, you know how witches are?
Yeah, that was in reference to, I asked him if he had ever called his mother a whore to her face. And he said, yeah, I did. I asked how his mom responded to that, and he said, she's a witch. You know how witches are. Oh, I'm better than you. I will be your fear. I will be your enemy.
Did you ask him to explain his mother's traumatic injuries?
Yes, about an hour and 18 minutes into the interview, I got to the point where I wanted him to explain the significant and severe injuries that she had. And when I asked him how she got these traumatic injuries, his response was witchcraft. I then specified that I was referring to the physical injuries to her body. He again responded witchcraft. I then asked him, I was going to need a little better understanding of how witchcraft could cause such injuries. At that time, Mr. Dazey ended the interview.
Did you leave the recorder on when you left the interview room?
Yes, the recorder stayed on until we were all done executing the search warrant on Mr. Dazey's person. So at the conclusion of the interview, that's when I told him that we had to collect evidence from him, provided him a copy of the search warrant. Carell and I then exited the room to gather up our gear for collection. After the fact, when I went back and watched the interview to type up my report, I noted that Mr. Dazey made some comments aloud while we were out of the room.
What did he say? What were the comments?
He stated, I would gladly spend an eternity in hell if she could just have a chance at heaven.
Was Mr. Dazey also alone in the squad car when you brought him to the port, when he was brought to the port down at the law enforcement center?
Yes, so Skorupski and I transported him from Mercy back down to the law enforcement center. Once we pulled into the Sally Port, the two of us, I exited the squad car. In that process, I dropped my portable radio, the battery bounced off, and we were looking on the ground for my battery. Then we got him out. So he was in the squad car for over a minute before we pulled him out. After the fact, I went back and reviewed that footage from the squad car.
Did he say anything during that time he was in the squad car?
He did. Mr. Dazey made a couple comments during that time. He stated at first, they will never figure out the psychology. You have a choice, conquer me or hell it is. He then paused, stated, I love you, I'm tired, and that was the end of the comments.
Now, before Mr. Dazey was taken up to the jail floor after the interview, did he say anything spontaneously?
Yes, it was actually, he and I were just standing in the interview room together because we had collected the Tyvek suit as evidence. I was waiting for Gorell to return with some clothing. We weren't talking, I wasn't questioning him, and he just stated aloud, witchcraft, brother, witchcraft. A lot that is wrong with my life. When people are trying to get in your way, when you are just trying to pursue happiness.
Did you tell him he was being arrested before he was taken up to the jail floor?
I did. He actually asked me if he was getting showered in, referring to going up to the jail floor. It was at that time I told him he was being arrested for the murder of his mother. His response was, it's hard to argue witchcraft in court, isn't it?
During all of your interactions with Mr. Dazey, did he at any time ever deny harming his mother or the dog?
Not once.
Thank you. I don't have anything further.
Cross-examination.
Thank you, Your Honor. On direct examination, you talked a little bit about watching the traffic cameras related to Kylie Frey or Kylie Dazey?
Correct.
All right. Are there any traffic cameras on Avoca?
There are not.
And which traffic camera were you watching on the corner of 24th and Jackson?
There's a camera at 24th and Jackson directed to the north, which captures the block in which she lives in, or lived in at the time.
And does it show the front door of her residence?
It does not. Her door is on the south side of the residence, recessed away from the street. The front door is actually for the apartment upstairs.
All right. And are there any other exits from her residence?
There is a back door on the main floor.
Okay. And I take it from your traffic camera, you couldn't observe those?
No.
All right. Life 360, and I think you talked about this a little bit, but Life 360 only actually tracks the phone, doesn't it?
Correct.
All right. So if the phone doesn't move, it doesn't track anything?
Correct.
All right. And is it fair to say that, I know you, is it fair to say that lots of people know about the thousands of traffic cameras in Dubuque?
Some do, some that have lived here forever, even actively involved in crimes, somehow don't realize it.
Okay. But lots of people do know about them, don't they?
Lots do, lots don't.
Okay. And they're not exactly hidden, are they?
No, they're not disguised in any fashion.
Okay. They're right out there sitting on top of the light poles.
Correct.
Now, you talked a little bit about quantum entanglement.
That was something Mr. Dazey stated to me right before he started urinating in the bathroom at the law enforcement center.
Did he explain to you what quantum entanglement was?
Tried to.
Okay. What did he tell you?
It's hard for me to explain.
If I were to show you your report, I think it appears in at least 2 different places in your report. Would that help refresh your memory?
Absolutely.
Yes.
I'm looking at pages 50.
Can you point out this one you're referring to?
Yeah, there's that one, and then over on 52, there's, he talks about it, and
this area.
Okay. I'm ready, Mr. Blair.
Now, did he kind of explain to you what he meant by quantum entanglement?
From what I captured from that is, if I was sitting at home and I was doing something, say I was drinking a beer, and I thought about you, Mr. Blair, then all of a sudden, wherever you were on this earth, that you would get the urge to drink beer, that I could put thoughts onto you.
Okay. He also used that term in reference to kind of a possession, didn't he? And I'll refer you to page 50. He specifically talked as it related to possession.
Are you referring to someone trying to take over your being? Is that? Yeah. Okay. He did make note of that.
On direct examination, you talked some about his mother practicing witchcraft. Did he explain to you how she practiced witchcraft?
From her bed, on cell phones with the other persons in the covenant, and that she would practice witchcraft upon him.
Well, and didn't he say that she did that by meditating upon him and putting thoughts in his head and possession and things like that?
Yes, he went into that.
He didn't actually talk about a conversation with his mother. He simply talked about witchcraft in response to you asking about the last time he had a conversation with his mother. Isn't that right?
I asked him when he last had a conversation with his mother, and he stated, right before you guys came in and got me, she was practicing witchcraft.
Right. He starts going into, right before you guys came and got me, she was practicing witchcraft. Is that right?
That was response to his last conversation, his last interaction with his mother.
Okay. He said lots of things that really didn't make a lot of sense, didn't he?
Well, every time we would get to something pointed and he would start, say, acknowledge that he had a hatchet, then when we would get more pointed, then he would take me in a different direction.
He also talked about being worshipped, didn't he?
Yes.
And that tied in with the quantum entanglement and the witchcraft, didn't it?
Yes.
And I think also somehow tied into when he took his medications.
Correct.
If I can have just a minute, Your Honor. Investigator Rosenthal, was the interview recorded?
Yes, sir.
The whole thing was recorded, wasn't it?
Correct.
And I think you actually talked about going back and watching part of it after you'd originally left the room.
Yeah, in all cases, I watch my interview in full so I can document the interview in a written report.
Yes. Approach the witness. Okay, folks, we're going to take a short break to discuss a legal issue outside your presence. This will probably be about 10 minutes or so. Remember the admonition I gave you before. Report back to the jury room.
All rise for the jury.
Washing machine and more searches for the sheets and blanket. And all of these indicate that he is trying to cover up his crime. He's looking for stain remover to try to get the blood out of the carpet. He ultimately does go to Walmart later that day around 6 p.m. and he does purchase duct tape, and he uses that duct tape to wrap Aaron in the blankets that he's ultimately buried in. Hydrochloric acid is famous because Jeffrey Dahmer used that on some of his victims. That was a search that the defendant made on best secluded locations. Ultimately, he buried Aaron in a secluded location, so that was part of his search of what to do with the body. So at this point, he has not buried Aaron, because because he doesn't have the duct tape and he hasn't found the location yet. And how to drain a washing machine, we know from officers that the next day they're going to discover bloody sheets in the washing room. And so he's already concerned because he's been using the washing machine to try to clean these things. Also, in between his searches to cover up his crime, he's also watching videos from No Country for Old Men.
I mean, you don't need me to explain the rule of completeness to you. You know what that means.
You make whatever record you want.
Essentially, Your Honor, the gist is that if they put in part of the story, we get to put in the rest of the story. And understanding this is one of the situations, a statement taken from a defendant, this is one of the situations where the rule of completeness directly comes into play.
Mr. Nelson, if you want to respond.
Certainly. This is not a situation where it's about completion because we did not play any portion of that interview. Had we done that, perhaps the completion might apply. It does not. Wanting to play part of that recorded interview is pure hearsay. There are no exceptions to that in the rules. And just because their client refuses to testify doesn't mean that they can come in and use hearsay to get that before the jury. If they indeed want the rest of the story, as they say, then the defendant can testify. He can say whatever he wants through testimony so that we can cross-examine him. That's what this system is all about, not about having testimony come in without the ability to cross-examine.
Mr. Blair, do you have any authority, any case law, or any rules that you want to cite to in support of your request?
I can get you the rule for rule of completeness. I kind of assumed that you knew which rule that was. Do you need that?
No, you made the statement that the rule of completeness automatically trumps any hearsay.
If you read the rule, that's what it's addressing. It's addressing situations where evidence would otherwise be kept out under the hearsay rule. And by implication, it overcomes the hearsay objection. That is specifically what it's addressing, is it's addressing situations where evidence would otherwise be kept out under the hearsay rule, under the rule against hearsay. And then that evidence is allowed to come in to complete the record, to allow the other side to respond and complete the statement. There is no restriction on whether that has to be done with witness testimony or whether it has to be done with, whether it can be done with a video recording of the statement that the witness was testifying about. The other thing about it, I would point out, Your Honor, is that my client has not, as of right now, has not refused to testify, and that's not the issue here. That's not an issue that's part of this decision, and it doesn't go into, it's not part of this. We're dealing with the fact that the state has put on part of it, has made assertions that are rebuttable with this, and we're proposing to complete the record and rebut those presumptions, those assertions.
You said the state has put on part of it. I think we can all agree the state has not shown any part of the video that you would like to show.
They have talked about what's on there.
Okay. So two components to this. Do you concede that what you want to play for the jury and offer into evidence is hearsay?
I would say that under the rules related to the rules of evidence, this would be an out-of-court statement by the defendant not being offered by the state, so it's not by a party opponent. Give me 1 second, please. I am going to refer you to one piece of relatively recent case law. State versus Flores. Iowa Supreme Court case from January 26th of 2024. Deals directly with the rule of completeness. It was a situation where the defendant brought up in testimony certain aspects of a statement within a CPC interview, I believe. The state was then allowed, in order to complete the record, to play the entire CPC video. CPC video. The only significant difference between these two situations is who's asking.
Give me a second. I found Flores. It looks like it's 2 Northwest 3rd, 287. I think the portion of that case you're talking about, the Iowa Supreme Court says the rule of completeness applies regardless of which party opens the door. And I think that's the point you're making.
That is the point, Your Honor. That is at least part of the point that I'm making. And also the fact that you'll note that they went from somebody testifying about a statement that was made to being allowed to play the video, even though the defense hadn't played any portion of the video.
That case is certainly a little different factually. It deals with sexual abuse of a child. Do you know the age of the child from that case?
I do not off the top of my head.
Okay.
But I would note that they're not talking about in their analysis, at least in this portion of it, they're not talking about what's the word? They're talking specifically about the rule of completeness and not the catch-all rule that allows you to go around hearsay for child victims. They're not. The residual exception, that's what I'm looking for. Thank you, Ms. Lassance. That's the word. They're not talking about the residual exception. They're talking about the rule of completeness.
So without having read Flores in its entirety, I said sort of two components here. The first one, I think you've conceded that what you're proposing to put into evidence and show to the jury is hearsay. My second question for you, if the state asks Officer Rosenthal one question about some interaction he had with the defendant, and Officer Rosenthal talks about one particular comment the defendant made, do you take the position that that opens the door to the entire video coming in?
Your Honor, I don't propose to be an expert about at what point the door is opened. There was a lot more here than one point and one comment. I understand your question, and I don't know the answer to that question.
Okay.
I would say that this is not that hypothetical, that this is a situation where they talked about it at length and where Investigator Rosenthal gave opinions as to whether or not Tyler knew what he was doing.
Okay, I understand that's not the circumstance. That's why it is a hypothetical. It's different than what we had here. I understand that. I think you get my point, and that is, at what point do you believe the door is opened up? And I think your answer is there isn't any fine line.
I think that's correct. I don't think there's some bright line that you can, but I think it's fair to say that that line's been crossed here.
Okay. For now, my ruling is, A, the state didn't show any portion of the video. B, what the state has offered up to this point in time is permissible. It's not hearsay. C, I think we've had a motion in limine that addresses this, and I think it was agreed upon by the defense. Now, that doesn't mean it automatically stays out. It means that we have to discuss it outside the jury's presence if you intend to go outside the motion in limine, which you have done, and I understand that. But you are entitled to cross-examine Officer Rosenthal about any portions of the video. You've seen it. You can ask him questions about things that the defendant may or may not have said. They may be objected to as hearsay. I don't know that. But you can cross-examine Officer Rosenthal on his expertise and his take on things that the defendant said. You're entitled to question this witness. I don't think you're entitled to put in, I don't know how long the video is, but a lengthy video where your client continually talks and discusses things that would be hearsay. I don't think you can shroud that under the rule of completeness and just say all of a sudden it all gets to come in even though it's almost entirely hearsay. I'm not going to let you show the whole video. You can offer it into evidence as a court exhibit if you want for purposes of completing the record and for appeal. But I don't think it's appropriate to let all of that come in when it is hearsay, and you have the right to cross-examine this witness.
May I make one point, Your Honor, in response? I would note, Your Honor, that while I can cross-examine him, I can't make him change his opinion. And he has made opinion statements about that. The jury is entitled to form their own opinion, but they're not being allowed to watch the actual interview.
I agree with everything you've said. What's your point?
Therein is the problem. The jury's right to form their own opinion has now been abrogated. It's now been curtailed. They're not being given that right.
Well, to the extent that he offered his opinion, he did so without objection. So if there was a question that called for an opinion and you don't believe that he was authorized to give that opinion, I didn't hear any objection, so it came in. You said I can't get him to change his opinion. I don't know if you can or you can't. That's cross-examination. But I understand your point. Any other record you want to make on this issue?
Your Honor, at this time, we're going to offer this as a court exhibit.
Let's call it E. E as in elephant. Okay. And you have a flash drive with the whole video on it. We will call that court exhibit E, and it will come in for that purpose. It will not be shown in open court. It will not go back to the jury.
And for the record, and I want to be 100% transparent about it, we did cut out the part where he asked for an attorney.
Okay.
So
understood. Thank you. Any other record from the defense on this issue?
I believe there is one reference in there that we were planning on cutting out, although we hadn't gotten that done yet, but there is one reference in there to his diagnoses, and that could easily be cut out.
Okay, understood.
It hasn't been on that exhibit, but it could. I was not proposing to show that portion to the jury.
Anything else from the state on this issue?
Yes, Your Honor. The fact that this interview was recorded really has nothing to do with the testimony. The recording was not mentioned except by the defendant. The state didn't play the video and didn't refer to it. And if what defendant is standing on is correct, then anytime there's a statement against interest, then a defendant would be free to play any recorded interview regardless of whether it's hearsay or not. It would just be a complete defeat of the hearsay rule, and it would defy hundreds of years of evidentiary jurisprudence. So I'm asking the court to overrule that and not allow that to be done, not allow it to be played.
Okay, and that's what I've already ruled. Mr. Hoover, do you want to give the court exhibit to the court reporter, please?
And actually, that's not true because he talked about it.
Okay, are we ready for the jury and to resume cross-examination?
Yes, Your Honor.
Okay. Okay, that's fine. Let's bring the jury in.
murderer. That's the main character, and his violent crimes and as he goes out. And one of the videos that the defendant specifically watches is a scene where the murderer has been injured and he needs to go to a pharmacy. So he blows up a car to create a distraction to go into a pharmacy. The defendant was also injured at this time. He's later going to search on for what to do about the cut on his finger. But just interesting that in between all of these searches about what to do with his best friend's body, he's also watching videos from a horror movie about a violent killer. All right, and so on Saturday, November 12th, he is still looking up carpet cleaning crew, also water damage restoration, and a company called Chattanooga Blood Spill Cleanup, and how to clean blood out of carpet. So there's the Chattanooga.
Another witness for the state?
We have no further witnesses, Your Honor, and the state rests.
All right, very good. Okay, folks, the state has rested. That means that we've received all of their evidence. There are a few things that the attorneys and I have to discuss at this point in time before we turn to the defense's evidence. So I'm going to give you a short break again. This break will probably be about 15 minutes or so. Remember the admonition, report back to the jury room.
Can we approach real quick, Your Honor, before letting the jury go?
Yes. Okay. The attorneys approached and told me that the defense has their witness here and ready to go. In the interest of continuing to move things along, instead of sending you out to organize their evidence, they've got a witness ready. So we're going to go ahead and start with a witness for the defense. Go ahead and call your witness, counsel.
Thank you, Your Honor. At this time, we would call Corporal Justin Stair. I apologize, Your Honor. I thought he was out there already. Okay, hold on.
You swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Go ahead and have a seat there. State your name and spell it for the record, please.
Justin Stair, Justin, last name Stair.
Go ahead, counsel.
Thank you. Corporal, you're a certified peace officer, correct?
Correct.
How long have you been a peace officer?
24 years.
And you're currently a corporal. How long have you been a corporal?
That was probably about 8 years now. Or no, sorry, more than that, 12 years. 11, 12 years.
And you, what did you have to do in order to become a corporal?
Just whenever there's a promotional exam, we take a test and then we have an interview and then they certify a list and pick from that list.
And what are your current duties?
I'm sorry, hold on 1 second. Okay, right now I'm a street corporal.
And how about back on January 18th of 2024, what was your assignment at that time?
I was a corporal back in criminal investigations.
And on that particular day, did you take pictures?
Yes, I did.
And do you have any idea about how many pictures you took?
Not right offhand, a lot.
Okay. I'm going to show you what's been marked as Defendant's Exhibit A. Okay. Do you recognize that photograph?
Yes, I do.
And was that a photograph you took?
Yes, it was.
And can you tell the jury where, in conjunction of the house, was that photograph taken?
So if you're looking at the house, it would be on the left-hand side where the driveway area.
Could you say that again? I apologize.
If you're looking at the house, it'd be on the left side of the house, which I believe that would be the east side of the house or southeast side of the house and the driveway area.
Okay. How far from the stairs would it have been?
I'm not sure by distance.
It would have been fairly close to the stairs?
If you're talking about the rear stairs, correct?
Yes.
Where the rear stairs was at, if they're here, it's somewhere further away from the stairs. I mean, we're like right at the base of it going up. I know that. It was somewhere right in on the driveway, more towards the driveway area.
Was there a particular reason you took a picture of this area?
Just taking photographs. This struck me as something to take a photo of. You know, if there's possible print or whatnot. At the basics of, or the base of the photos is just taking overalls of everything as you can see, or as is.
Sure. Did you have an opportunity to observe the rear door?
Yes.
And did you have an opportunity to observe the steps at the rear door?
Yes.
Okay. And what were your observation of those stairs?
Obviously, there was snow on them, snow covered, and there was prints or impressions in the steps.
Did you take any pictures of those?
No.
Was there any particular reason why you didn't?
No.
Then there's, could you put it down for a minute, Your Honor? You also took some pictures of tracks, correct?
Yes.
And I'm going to show you what's been admitted as Defendant's Exhibit C. Okay. And are these the tracks that you took a picture of?
Yes.
Okay. And were you ever able to make any kind of determination as to what made those tracks?
I knew they were definitely animal tracks.
Okay. Do you have any kind of idea what kind of animal?
My guess would be a rabbit or a squirrel. I live in the country and I see those all the time every winter. So it's one of those animals.
Do you have any idea about how deep the snow was?
I don't recall right offhand how deep it was.
Did you take any close-up pictures of those tracks?
I thought there was some that took closer photos, if I remember right.
Just have a minute. I don't have any further questions. Thank you, Corporal.
Cross-examination.
Thank you, Judge. Good afternoon, Corporal Stair. How are you today?
Good.
Good. Okay, so one thing we can see from these photos is that it is definitely, can I keep that up, Mr. Hoover? Thanks. It's definitely snow covered out there, right?
Yes.
In your experience as a person and a officer, how great are photos taken in white snow?
Not very good.
Okay. You did take close-up photos of those tracks though, correct?
I believe I had some that were a little closer.
All right, may I approach?
Yes.
I'm handing you what I marked as State's Exhibit 42. There are 2 photos here. Can you take a look at those? Can you tell me what those are, Corporal?
Yes, like the animal tracks that I saw before.
And that you took a close-up of these tracks in Defendant's Exhibit C?
I believe so.
Okay, can you see in those photos the tracks up close?
Not really.
It's difficult,
Yes.
but can you make them out?
In this one, yes. And at an angle, yes, you can kind of see them here as well.
Okay.
It's faint, but you can see them.
And in those photos, what do those tracks appear to be to you?
Animal tracks.
Okay, move to admit State's Exhibit 42.
Any objection?
No, Your Honor.
42 is admitted.
Can we take that? Take the picture down. Are you done with it?
Yeah. Okay, can you put up your exhibit, was it C, Mr. Hoover, the other one you referenced?
A.
A. Can you put that one up, please?
On a minute. Let me just. All right. It's up, Your Honor.
Thank you. Okay, does it appear in that photo that there are several fairly distinctive footprints or tracks?
Yes.
Okay. Could it also be possible that there could be footprints or tracks from within the home or somewhere else around this crime scene?
Correct.
And would it make sense for you as an officer to photograph this in case those things are found so you can do a comparison?
Correct.
Because snow melts, right?
Yes.
Those tracks are going to be gone at some point.
Yes.
Okay. And may I put up, can you put up the states, please?
Yes.
I'm putting up Exhibit 8. Okay. Corporal, you have a laser pointer up there, right?
Yes.
Actually, I think I'm going to take it from you.
Okay, go right ahead.
In the first photo in State's Exhibit 8, You see the staircase there?
Yes.
Okay, and anywhere in front in this photo, do you see an area where defendant's exhibit A could potentially be from within this photo?
No.
Okay. Now in the second photo in State's Exhibit 8, we have that same door right there, correct?
Yes.
Okay, in the corner down here, we see what appears to be a bit of concrete. Do you see that?
Yes.
Would it make more sense that that is the spot that they're referencing in that previous photo?
It could very well be.
Okay, and as you looked in the sequence of the photos that you did, let me ask you this. Do you typically take photos in sequence as you're processing a scene?
When doing overall photos, yes.
Okay, and would it make, and you did it in a sequence in this case, correct?
Correct.
Okay, so would it make sense in your sequence as you reviewed it, that this area would make more sense for the photo that they're referencing?
Correct.
Okay, and that's where? The driveway?
Yes.
Would it make sense that that area of melted snow surrounded by snow, ice, tracks was made by a car at some point?
Could have been, yes.
Okay, no other questions.
Mr. Hoover?
Thank you. I'm just going to keep that up, if that's okay. Yeah. Okay. Corporal Stair, I think this is the area you were talking about right down here, correct?
Yeah, somewhere in that area where I believe that print was from, yes.
And would there be any possibility of someone entering the house from this position right here?
Could they wave? Yeah.
Would it make more sense that someone might have entered the house from over here?
They could have.
Okay. No further questions.
Nothing else.
Thank you, sir. You're free to go.
Thank you.
Okay, folks, now there are some issues that the attorneys and I will go through. We'll give you a short break. 15, this will probably actually be a little bit longer break, probably 15 or 20 minutes. Remember the admonition, report back to the jury room.
All rise for the jury.
Please be seated, everyone. Okay, the record will reflect that we are now outside the presence of the jury. The state rested their case. We had a sidebar. All parties agreed that rather than the defense making motions at that point, we were going to take the testimony of Officer Stair because he was here, and I think believed to be fairly short. The defense will make any motions they have now. The court will consider those motions to have been made at the close of the state's evidence and to be timely. Mr. Nelson, you agreed to that?
That is agreeable.
Okay, very good. Any motions from the defense? Go ahead.
Thank you, Your Honor. At this point, we would make a motion in judgment of acquittal. Looking at the evidence in light most favorable to the state, Your Honor, the state hasn't presented any evidence of malice or forethought or premeditation as required in elements 3 and 4 of at least the uniform jury instructions. Your Honor, in fact, the evidence of kind of what happened is fairly scant, other than definitely there was a homicide that took place, but there's little to no evidence that there was premeditation involved in here. There was any kind of planning. There's little to no evidence of malice or forethought in this particular case. Additionally, I would say that the state hasn't even met its burden as far as Tyler Dazey is the one who committed these actions. All we have is Mr. Dazey was in the residence and that he owned something that may have caused these injuries. No affirmative evidence saying that Mr. Dazey possessed it on that day or used it on that day. So we believe that murder 1 and murder 2, there has not been a sufficient question for the jury made. As to any of the other lesser included, including voluntary manslaughter, we won't at this point make a motion in judgment of acquittal for any of the remaining lesser included, aside from number 1, that again, the state hasn't generated a jury question looking at the light most favorable of the state that Tyler Dazey was the one who inflicted these wounds. And then as far as the animal abuse, Your Honor, while certainly, again, the state has failed to prove or at least generate a jury question looking at the light most favorable to the state that Mr. Dazey inflicted any serious injury, death, or injury on the animal. But additionally, the code section specifically has an exception, which if the defendant was the owner or didn't have or had the owner's permission to euthanize the dog in a reasonable manner, if the animal is in a permanent state of pain or suffering, and again, looking at the evidence in the light most favorable to the state, 1, the state hasn't proved that the defendant wasn't a co-owner of this dog, that even if he was a co-owner, that he wasn't acting at the behest of his mother, and that the testimony that was given was that it was 1 strike and the dog died instantaneously. And again, the state hasn't provided any evidence that the animal wasn't at the time in a state of pain or suffering. So with that, Your Honor, we would ask that you grant our motion and judgment of acquittal.
The state's response.
Thank you, Judge. In reference to the status of the dog, our first witness said that the dog was Jenny's dog, and that under the statute is all the state would have to prove, and we don't need to prove that dog to the exclusion of all potential owners. That would be something the defendant would have had to need to bring up. When it comes to the elements presented to the jury, the state's position is certainly that a fact question has been presented to go to the jury's consideration. Evidence was that when Nick showed up at 1605 Avoca Street on January 17th, approximately 8:00 p.m., Tyler was home that night. Ring camera from the front of the door shows Jennifer Dazey letting Echo in from going outside at 10:00 p.m. There is no more movement on that camera until 8:38 a.m. when Christy Fullman arrives at the home. What does she see? Tyler Dazey naked. As she sees him, she waits, and he then goes into another room. She then proceeds to locate Jennifer Dazey in the bed in the same residence with one Tyler Dazey. Police are called and they respond. It's clearly a gruesome murder scene. And long story short, they process the scene. They find a tactical hatchet that clearly is capable of producing the wounds that Ms. Dazey suffered, as well as the wound that Echo Dazey suffered. The medical examiner also testified to that same fact. If the jury looks at the photos themselves and looks at the hatchet, they are able to make a determination as to whether or not that hatchet, owned by Tyler Dazey, seen by him that morning upon his own admission, was in fact the weapon used in those crimes. When it comes to the issue of premeditation, deliberation, malice aforethought, and all the other things. Number one, the state has alleged, and I believe proven, that a hatchet was used, which is a dangerous weapon, which changes the discussion for the jury. Second of all, if that is not determined, the state has shown that there were 17 separate wounds to Jennifer Dazey, 1 wound to Echo, that's 18. The jury can hear argument as to what that means and will be given an instruction that those things, premeditation, deliberation, all those things, do not require any specific time. But the state alleges that that would take some time to swing that hatchet 18 times. The state believes, considering this, even despite other doors on the home, there is an ultimate fact question as to whether or not the defendant committed these acts, and the evidence has tied him to it. And we are asking that you deny the motion.
Your Honor, we would propose that the state's theory of premeditation would essentially make it impossible to have anything other than murder in the first degree. That if you struck more than once, then that automatically meant that you had premeditation, and that's just not what the standard is. So.
Okay, I understand the argument both ways. I think what the state's saying is, if there's one shot and you pull the trigger, it's instant. If you swing something as dangerous as a sharp axe and swing it 17 times, that there's time in between each time that you strike a blow with that. That's the argument. And I understand the defense's point is, well, does that mean every time someone is hit more than once with a dangerous instrument that it automatically creates premeditation? I get it both ways. That helps to show that on that issue, it's a fact issue that the jury's going to have to weigh and have to decide. The motion made by the defense has to be considered in the light most favorable to the moving party. In this case, I won't rehash all of the evidence, but we certainly have enough evidence in the record to generate a fact issue as to both counts, count 1 and count 2. I am going to deny the defense's motion for judgment of acquittal at this time. Any other motions from the defense?
No, not at this time, Your Honor.
Anything from the state at this point?
No, Judge.
Okay, we'll go off the record. The record will reflect that we are now outside the presence of the jury. Both parties have rested. Any motions that the defense wants to make at this time?
Your Honor, we would just renew our previous motion.
Okay. Any response from the state other than what has been stated before? No, Judge. All right. I will consider the motion and the same arguments that were previously made and the resistance made by the state. For the same reasons I gave before, there is a fact issue that has been generated that the jury will have to rule on. I am going to deny the motion again for judgment of acquittal. Anything else from the defense at this time? From the state?
No, Your Honor.
Okay, we'll go off the record. Yeah, we didn't call it anything. Amanda, is that on that flash drive?
That's all that's on this.
Is that the video?
Yes.
Okay. We didn't call it anything on the record. I'm not making it no. See you guys.
See you later.
Good night.
Have a good night.
D&E. Yeah. So Judge, on D, I did do an exhibit placement and I called it court exhibit D. Do I need to do that? Yeah. Well, I think the appellate court can look at it either way. That's what makes a court. Oh. Oh. Well, I think that's why we. In my placeholder, I specifically put it that it was a court exhibit, so. Okay.
Everybody uses placeholders, so everybody uses placeholders in EDMS.
Yeah.
They make photocopies of the disk and upload that.